Right now you're on. Say hello. I don't know if you'll know.
Please rise. Justice of the Appellate Division Supreme Court First Department. Hear ye, hear ye, all persons having business with the Appellate Division. Come on here, give your attendance, and shall be heard. Please be seated.
Okay, good afternoon, everybody, and welcome to the Appellate Division First Department. We have 7 hours of argument scheduled, so I'm going to have to ask you to please just request the time that you really need on these cases. Remember, we've had your briefs and your records, and we've had an opportunity to become pretty familiar with the cases. You know, when the white light goes on, you have 2 more minutes. When the red light goes on, you're supposed to stop. You don't have to stop in the middle of a sentence. But if we have additional questions, we will continue asking you questions. The red light is for you. So let me begin with the first case on the calendar, People versus Ruperto. Okay, 5 and 2 and 5. Thank you. Stovall versus Lenox Hill.
Good afternoon. Unless the court has any questions, appellant would be willing to mark this submitted.
Respondent? I don't think anyone has any questions. Okay, well, thank you very much. We'll mark it submitted. The next two cases are S. Chilton. They are both submitted. Bradshaw versus City of New York, submitted. Innovative Concepts versus AL Infinity. Appellant? Is the appellant here? No one checked in? Okay. Yes. Do you want to argue or do you want to submit? Okay. I'll mark it submitted then. Okay. I guess we're sort of cutting the time down, aren't we? People versus Damir Jones.
Good afternoon. Appellant request 5 and 2.
Good afternoon. Respondent request 5.
Okay, thank you. 5, 2, and 5. Echeverria versus Bernstein. Okay, and respondent? Okay, 5 and 5. Prismatic Development versus New York City Transit Authority. Respondent? Excuse me? 10. How about 6, 2, and 6? If we have additional questions, we'll keep you going. Thank you. ACC Construction versus Merchants Mutual. Good afternoon. Okay, respondent? Okay, 6, 2, and 4. Samuelson versus Woolman Rink. Okay. Excuse me?
5 and 1, Your Honor.
Okay, and the respondent? 4. So 5 and 2 for Woolman Rink, 5 and 1 for Classic Carpet, and 4 minutes for respondent. Thank you all very much. Olson versus Brentag North.
Good afternoon, Your Honor. It's very complex.
Yeah, we're aware of the case.
We're wondering whether there's any chance to get the full 15, but if not, then it's
How about 10 and 2 and 10? I think that'll probably cover it. Okay? Thank you both very much. Church of Jesus Christ versus Kelly is submitted. People versus Juan Rosario? Submitted. Crimless versus City of New York? You're Bleecker, correct? Okay. Okay, and there's one other respondent?
for respondent answer, Your Honor, 5 minutes.
Okay, 5 and 2, 5 and 5 for the respondents. Excuse me. Thank you. People versus Ralph Terrain? Yeah, I mean, I think they agree with your request. So does anybody need to argue?
That's my question for you, Your Honor. Do you have no questions about responding to conceding jurisdictional issues? I'm happy to submit.
No. I think that was sort of explained it, so I don't think we have any questions about that. The only question is, why were you going to argue? So now you answered that. Okay, we'll mark that submitted. Thank you very much. BSR Fund versus Jagannath. Okay, and respond?
For the entity respondents, that's Icon Finance, Icon Europe, Icon.
Yeah.
We request a 5, Your Honor.
And you're the Chu respondents, the other person? Oh, Latina, okay. So 5 and 3. Is that what you said?
Yes, Your Honor.
Okay. 5 and 2 for appellant, 5, and then 3 for the respondents. Thank you. Una RTY Corporation versus NY.
Good afternoon, Your Honor. Appellate Agricultural Bank of China and Chinese Construction Bank, request 5 and 2.
And respondent?
That's 5 for the response, Your Honor.
It seems to me you pretty much have the same position, so I'll give you 5 and 2 and 5 and 2, but if you're going to repeat, we'd rather, try to work that out. We won't get to number for that one for a while, so maybe you can figure it out. Thank you. Newmark Partners versus Hunt?
Good afternoon, Your Honor. Appellate request 5 and 2. Good afternoon, Your Honor. Respondent request 5.
Yes, thank you. That's what I gave you. Thank you very much. 5, 2, and 5. And last, People of New York versus Schiraldi. That's the habeas corpus.
Good afternoon, Judge. Appellate request 5 and 2. Good afternoon, Your Honor. Respondent request 5.
You've got it. 5, 2, and 5. Okay, thank you very much. Please remember to keep your masks on when you're arguing. Believe it or not, we actually can hear pretty well. You speak clearly into the mics. First case for argument is number 1 on the calendar, People versus Ruperto.
Shall I begin?
Good afternoon, you may begin.
Good afternoon, Your Honors. Katrina G. Myers from the Office of the Appellate Defender for Gilrael Ruperto. The photo of the lineup shows Mr. Ruperto, an undomiciled 5-foot man with a skeletal frame, standing between 5 NYPD fillers.
Well, wasn't he really, they were all seemed to be sitting and they had like a black plastic covering to hide everything pretty much from their chin down. So it really wasn't like you could really, we looked at the lineup photos. So I'm not sure that the distinction that you claim necessarily came through in the pictures.
Yes, Your Honor. The lineup photos do show a difference in Mr. Ruperto's height. He is lower in the frame than the other individuals.
Well, isn't it true that filler number 6 is also lower? He's the same level as Mr. Ruperto.
That's correct. However, Mr. Ruperto's head is also a different circumference. His head is tiny. He's a 5'1" man. He also has very long hair that can be seen swooshing beneath the side of his hat.
But they all have baseball hats turned backwards, right?
That's very true, Your Honor. However, his hairstyle is very apparent in the photograph in comparison to the NYPD officers who looked very similar to one another. They all had crew cuts. They were all relatively well built. Mr. Ruperto was undomiciled at the time. He was skeletal. He was withdrawing from heroin. He looked nothing like the NYPD fillers. And in comparison to their very similar appearances, he stuck out like a sore thumb, and the lineup procedure was unfair. The detective who administered the lineup also admitted that the differences were were apparent in the lineup procedure. He described Mr. Ruperto as appearing shorter and smaller, and he noted that Mr. Ruperto had long hair. He further didn't make any effort to validify his procedure in any sort of way. He didn't fill out any of the paperwork properly. The lineup administration report wasn't filled out. He was supposed to document the NYPD officers' ages, heights, physical descriptions, and he failed to do so. He additionally failed to note the administration of the procedure, the questions he asked the complaining witnesses and their responses. So the administration of the lineup was also unreasonable. Further, it was tainted by a photo array that was already found to be unduly suggestive. The same detective failed to preserve the photo array and put it before the court, so the magnitude
Well, it was only one of the witnesses that even saw the photo array, correct?
That's correct. That's correct,
And
Your
that was
Honor.
2 days before the actual lineup.
46 hours beforehand, she saw a photo array procedure that was not put before the court, and she
Counsel,
was
are you
kept.
referring to the photo where the defendant appears to have short hair, a piercing, and a facial hair?
Yes,
and
that
facial
photo
hair
was taken, I
year
believe, a
earlier?
year and a half before the instant crime.
Well, doesn't this photograph help the defendant because they don't exactly look the same, or do you think they look the same?
Can you repeat that, Your Honor?
Does this photograph help the defendant? Do they look the same or do they look different?
From his appearance in the photo array versus the lineup,
Yes.
it's hard. I'd say his facial structure looks the same. His hair is obviously different. He's shown with long hair in the lineup, and he has shorter hair in the photo array.
So does that help or hurt the defendant?
I'd say, Your Honor, that it could possibly hurt the defendant in a way, although I do believe the lineup procedure was so egregious that it would trump any sort of hurt that would be caused from the photo array procedure. He is obviously the same person. He's obviously this tiny man with a skeletal frame who looks exactly the same as he does in the lineup, except for the fact that he has very long hair.
The photo array was suppressed by the trial court, so your issue really is with the lineup, is that correct?
Yes, the issue is the lineup. The issue is the lineup, and we're arguing that the photo array, which was found to be unduly suggestive, tainted the subsequent lineup procedure, which occurred 46 hours later. Mr. Ruperto appears to be relatively the same in appearance in the photo array in comparison to as he looks in the lineup procedure. The showing the complaining witnesses that array and also indicating that they had a suspect from the array in custody made the procedure unduly suggestive. And if I may address Mr. Ruperto's excessive sentence point on rebuttal, that'd be
Absolutely.
appreciated. Thank you.
For sure. Thank you very much.
Good afternoon, Your Honors, Counsel, and may it please the Court. My name is Reva Grace Phillips, and I'm here today on behalf of the respondent, the Bronx County District Attorney's Office.
Counsel, if you can just address the time between the photo array and the lineup, if it was sufficiently attenuated or not, what's the people?
Absolutely, Your Honor. Your Honor, the photo array, which occurred 2 days before the lineup, was sufficiently attenuated. As this court held in 1992 in People v. Dabdob, a 2-day period of time between a photo array and a lineup was sufficient attenuation. Additionally, as Your Honor pointed out, the fact that the photo array picture looked different than defendant at the lineup undercuts an argument that it would taint it. In People v. Rodriguez in 1984, the Court of Appeals found that where a defendant had lightened his hair, shaved his beard, and lost weight between a photo array photo and a lineup, that did undercut any suggestiveness from the photo array. And Your Honors, I'll briefly return to the fact here that while defendant attempts today to relitigate his loss suppression hearing and undo his agreed upon plea bargain, he is barred from both claims by his valid waiver of the right to appeal. And I specifically point to the court's colloquy here, where the court distinguished the appellate rights from the trial rights.
Before we get there, so your adversary stated that Polanco, the officer here, he failed to fill out a lineup information report and to document the names, the ages, and heights and weights of the lineup fillers. What effect should that have had on the determination here?
Your Honor, that should have no effect. The detective didn't entirely not fill out the paperwork. What he did write was MOS, indicating that these were members of service. However, I concede he did not write their ages, weights, and heights. However, as the Court of Appeals held in 2002 in People v. Jackson, if there is a photo introduced, you have to be arguing there are actual discrepancies in the photos. It's not enough to say there's a numerical piece of information lost. They held there that specifically where the number, the ages were different, but the argument wasn't they looked different in age in the picture, that the numerical difference did not matter. And similarly here, it's about how the photograph looks. As defendant put it repeatedly, I believe, in their brief, the photo is worth 1,000 words here, and I think the photo reveals it was not an unduly suggestive lineup. I return to the waiver of the right to appeal to make one point to this court, which is that this colloquy is almost identical to the colloquy upheld by the Court of Appeals in People versus Thomas. That's no great surprise, given that Judge Michael A. Gross presided over the plea and sentencing of defendant Thomas and also defendant Ruperto just 2 months after the Thomas colloquy. Here, the language is almost identical to the language upheld by the Court of Appeals. The waiver here is even stronger. In Thomas, the Court of Appeals was somewhat concerned with the fact that the written waiver included no notice of appeal language. The waiver here did not include that language, making this waiver even stronger, and the collective waiver even stronger. Your Honors, I've already touched on why the lineup was not suggestive. The lower court correctly found that the fillers were sufficiently similar to the defendant. Unless Your Honors have additional questions.
What about the fact that the oral waiver didn't specify what rights survive?
Pardon me, Your Honor?
What about the fact that the oral appeal waiver didn't specify what rights survive that waiver?
Your Honor, as the court held in People versus Thomas when it upheld almost the exact same colloquy, the court is not required to engage in any particular litany. And here where a defendant, counseled by 2 defense attorneys, indicated on the record he had time to review that waiver with his counsel and signed a written waiver that expressly advised him of some of the many appellate rights he retained, a defendant's waiver was clearly knowing and voluntary. I want to end by uplifting one of the voices of the victims here when talking about excessive sentence. I start with excessive sentence by noting defendant faced a very real possibility of 50 years. And I don't mean that as the theoretical upper limit of what he could have gotten. The prosecutor repeatedly said on the record that the people would seek both consecutive sentencing and upper range sentencing. Prior to voir dire beginning, the court, attempting to make sure that Mr. Ruperto was aware of the sentencing range he faced, advised that it would take very seriously the people's recommendations to upper range sentencing and consecutive sentencing, given the conduct here. I raised the voice of Ms. Garcia in closing. Ms. Garcia's son was contacted by probation when they prepared their pre-sentence report. He told the individual he spoke with that his mother had been so scared after defendant's violent assault on her in her own apartment building that she no longer felt safe leaving her apartment to do such simple tasks as getting groceries or her mail, that her son would come up from Brooklyn to do as little as get her a carton of milk or bring up a piece of mail to her because she was so scarred by defendant's conduct. And that's a defendant who intentionally stalked and then assaulted her and robbed her, a 74-year-old woman, in her own apartment building. And what he said to probation in closing, I think, is incredibly important. He said, only once his mother had heard that the defendant pled guilty, if Your Honors, if I may briefly conclude.
You just finish your sentence.
Yes, Your Honor. He said that his mother, only upon hearing defendant had pled guilty and what his sentence was, began to have confidence again in going about living her daily life. I ask that this court affirm her confidence in both his sentence and the criminal justice system by affirming his conviction. Thank you.
Thank you. You have 2 minutes for rebuttal.
Thank you, Your Honors. To address the respondent's point about the waiver in Mr. Ruperto's case was not valid. It totally mischaracterized the right to appeal by saying it was a complete bar on the right to appeal. The plea court said that Mr. Ruperto would not be able to raise any issues that arised at the plea or sentencing. Mr. Ruperto reasonably relied on the judge's representations during the plea colloquy and entered his plea in response to those representations. Courts have consistently found that written waivers do not cure these oral deficiencies, and this court should reach Mr. Ruperto's suppression issue and excessive sentence issue for those reasons. Briefly, respondent seems to suggest that the court should look at the individual circumstances of the lineup. This court should look at the totality of the circumstances. The fact that he's 5 feet tall, has long hair, has a skeletal frame, and was put in a lineup with 5 NYPD officers. In Rojas, this court reversed a suppression ruling for this exact reason and should do so here, as respondent concedes Mr. Ruperto is child-sized and the NYPD is not. As for his excessive sentence point, 10.5 years is excessive for Mr. Ruperto, who committed his crimes while he was undergoing heroin withdrawal. He is also very small and has suicidal ideations and is currently being housed in a maximum security facility. These circumstances make his punishment unduly harsh. Mr. Ruperto turned himself in and confessed to the crime. He apologized multiple times. He begged the officer who, the detective who later conducted the lineup, to get him medical attention and to get him help for his addiction, which he blamed as the cause of the incident in question.
And counsel, his sentence was enhanced because the two incidents were characterized as hate crimes, am I right?
Can you repeat the last part, Judge? I'm sorry.
His sentence was enhanced as because the robbery too was denominated a hate crime.
Yes, Your Honor. The
Because
robbery.
he preyed on
Yes, Your Honor.
older
And he was
women,
sentenced to
right?
3 additional years because of that fact. If it weren't a hate crime, he'd be, the minimum would be 5 years. Here, he's asking you to reduce it to 8. If you read his statement to the police, he clearly did not have animosity towards the elderly. And we are asking the court that they reverse their suppression ruling and, in the alternative, reduce Mr. Apierto's sentence. Thank you.
Thank you. Thank you both. The next case for argument is People versus Damir Jones. Good afternoon.
Good afternoon. May it please the court, Chloe Warnberg, legal intern with the Office of the Appellate Defender, on behalf of Mr. Damir Jones. The sentence in this case should be reduced because Damir Jones has an IQ of 58, which places him in the bottom 0.3 percentile. He's lived a lifetime of trauma, including sexual abuse and medical neglect and parental neglect from an early age. He suffers from untreated mental illness, including post-traumatic stress disorder, and he was only 20 years old at the time of the crime. Each of these factors is uniquely mitigating in the jurisprudence of this court and also the United States Supreme Court. This court has repeatedly recognized these factors as justifying a reduction in the interest of justice, and it's hard to imagine a case that presents more mitigating factors than those in Damir's case. Damir has lived a lifetime of unrelenting trauma from when he was as young as 6 years old, and his mother failed to take him to his medical appointments.
I know the IQ is said to be 58, although the circumstances of the crime hardly bespeak someone with an IQ of 58. After all, he acts with Hall and Cameron to corner this person in a restaurant, and then the victim is forced to escape from a different door, and then the defendant runs after the victim and fires 4 shots at him from I think was it a 45 caliber? Whatever. He fires 4 shots at him with the idea of, then he says he just meant to scare him. Doesn't quite seem to be the thought process of someone with an IQ of 58.
I'm sorry, could you just repeat that last part? It's a little, I had a little trouble hearing.
The circumstances of the crime doesn't seem to be those of someone with an IQ of 58.
Your Honor, first of all, we're not debating the facts of the crime or the severity of the crime, and we would also point out that
I'm not talking about the severity, I'm talking about the thought process that went into this crime.
Yes, Your Honor. The question before this court is not whether people with severe intellectual disability can commit crimes. People with severe intellectual disability can make simple plans to do things like go to the grocery store and then follow through on that. What we are arguing here and what we know from the U.S. Supreme Court's jurisprudence and brain science is that severe intellectual disability interferes with an individual's ability to make good decisions in highly stressful situations.
My point is, of course, anyone is capable of committing a crime. The point is the inconsistency or the dissonance between the circumstances of the crime and the severe cognitive deficits that you present.
Well, Your Honor, I think that it's, like I said, we're not debating the facts of the crime, but the expert report that was submitted during the trial court says that Demir Jones has an IQ of 58, which makes him significantly intellectually disabled. And what we know is that that affects an individual's ability to make decisions in highly stressful
Counsel,
situations.
could you address the defendant's criminal history, his priors?
Yes,
And
ma'am.
fit that within the context of what you're arguing?
Yes, Your Honor. So we did want to correct for the record that Demir has no prior felony convictions. He does have a misdemeanor conviction and a youthful offender adjudication. We wanted
And the
to,
youthful offender was for robbery 2 and menacing 3, right?
yes, Your Honor, I believe that's correct.
He's received received a sentence of 1 to 3 on that?
Sorry,
Was his sentence on that 1 to 3?
I believe that's correct. We would just point out that Demir has experienced, as I mentioned, a lifetime of trauma and undiagnosed and untreated mental illness that unfortunately he wasn't even diagnosed with post-traumatic stress disorder until 2018 after this current crime was committed. And when he's released from the current incarceration, it will be the first time in his life that he's going back to a family member who is supportive of him, which is his wife, Navia. Demir and Navia got married after the current offense. And I mean, this is the first time in his life he'll be released to someone who cares for getting him the services.
When the crime in question was committed, right?
Sorry?
They were together when the crime in question was committed, am I right?
Yes, Your Honor, but I'll just mention briefly, they have since gotten married, and at the time the crime was committed, Demir wasn't living with Navia, he was living with his mother, who had always been neglectful of his needs and was experiencing severe drug addiction. Thank you, Your Honor.
Okay, you'll have 2 minutes on rebuttal. Respondent?
Good afternoon, Your Honors. David Gagne for the people. Defendant's sentence was fair and appropriate given the seriousness of his crimes. In fact, in his brief and now today, defendant admits that his crimes were in fact serious. Armed with a semi-automatic pistol, defendant worked with 2 other individuals as he attempted to corner the victim inside a restaurant in broad daylight. After the victim managed to escape from the restaurant, the defendant chased after him and fired 4 shots in his direction. Each one of those shots could have easily harmed or even killed the victim or some other innocent person walking down the street.
How does the defendant's IQ of 58 factor into your argument?
Well, Your Honor, clearly the defendant was capable of understanding what he was doing. After his arrest, he made statements to the effect of, well, I didn't mean to kill him. If I wanted to do that, I could have done it inside the restaurant. So while, of course, cognitive disabilities is a factor to consider, the trial court has already considered that and given a rather lenient sentence at 7 years. The maximum sentence for attempted assault in the first degree is 15 years.
So, counsel, in addition to the IQ, there are other factors here that possibly suggest that leniency is appropriate, right? We have the family issues, where he's abandoned by his father. We have the issues that he had with his mother, some homelessness, special needs student, moving from shelter to shelter, sexual abuse, drug use, and so on and so forth. Why should we not consider that in reducing sentence?
Your Honor, it's very within your right to consider it. However, I would also just recognize that the trial court did consider those factors as well. The defense prepared a pleading memorandum. There was also a psychological evaluation that was conducted and that was presented to the trial court prior to the judge accepting the defendant's plea and imposing sentence. So when you consider the fact that 7 years is less than half of what he could have ultimately received, I think these factors have already been considered in light of his sentence.
This IQ score of 58, do we know which IQ test was given? Is there anything subjective about the score?
Your Honor, I don't believe there's anything in the record that contains that information.
Was there any challenge to that number?
Not that I know of, Your Honor. And if there are no further questions, I rest on my brief. Thank you.
Thank you very much.
Your Honor, the law is clear that this court has the discretion to reduce a sentence in the interest of justice without any deference to the sentencing court. I would also note that the sentencing court in this case was confronted with the question of an appeal waiver and stated on the record that she felt an appeal waiver was not appropriate in this case. So the question before this court is whether Demir's sentence is unduly harsh or severe, and we would argue that it is. Under the U.S. Supreme Court's jurisprudence, a just sentence takes into account not only the severity of the crime, but also the characteristics of the person. And in this case, Demir is one of the most intellectually disabled members of society. That, in conjunction with his youth at 20 years old, his lifetime of trauma, including sexual abuse and mental neglect, parental neglect, and no supports to counteract that trauma, along with undiagnosed and untreated mental illness and post-traumatic stress disorder, these are all factors that this court has held mitigate against a lengthy sentence and justify a reduction in the interest of justice. We would just urge this court to see Demir's characteristics and see that the sentence that he received does not sufficiently reflect all of the extensive mitigating factors that are uniquely mitigating under this court's jurisprudence and the U.S. Supreme Court's jurisprudence. With an individual who has an IQ of 58 and was 20 years old at the time of the crime, the sentence must reflect those factors in taking into account the context of this crime. And I would just reiterate that this is the first time in his life that Mr. Jones will go back to a supportive family member when he is released from incarceration in his wife, Navia. If there are no more questions, we ask that Demir's sentence be reduced in the interest of justice. Thank you.
Thank you. Thank you both. Next case for argument is Echeverria versus Bernstein. Good afternoon.
Good afternoon, Your Honors. May it please the court, my name is Marcia Rakes, and I'm here on behalf of the plaintiff appellant. Thank you very much. This medical malpractice... Counsel, I want to just start out by talking about the expert affidavit that was submitted by plaintiff. It's been suggested it was conclusory, speculative. How do you address the items covered inside the plaintiff's expert affidavit? I'm sorry, Your Honor, I have trouble hearing. Okay. I want to talk about the plaintiff's expert affidavit, right, that was submitted in support of the position that other tests should have been done at the time the plaintiff presented to his treating physician. The report appears to be speculative or conclusory in terms of what other tests should have been done. How do you address that? Well, I have a couple of arguments to address the admissibility and persuasiveness of the plaintiff's physician affidavits. First of all, record 2292 and 2293 show that the physician's signature was duly notarized, and it was also accompanied by an affirmation of compliance. I'm not talking about that particular issue. Moving on to the substance of it. I would say that the admissibility of the persuasiveness of the physician's affirmation appears in the Browder case, was cited in the respondent's brief. If I may please point out that this very court abrogated Browder.
Let's talk about the record, the medical record, on what did the physician base his or her conclusions? Because here meningitis was the ultimate result, right? That was the ultimate diagnosis and the one that resulted in the death of the decedent. But when the decedent presented, there was no disorientation. The fever, having taken aspirin, was 98.3. There was no stiff neck. How do you get around the description that the physician's affirmation was conclusory?
If I may say, Your Honor, that I don't see in the medical records that the plaintiff's decedent's neck was examined. He wasn't asked to go through his ranges of motion and asked if his neck hurt. He complained about nausea, loss of appetite, vomiting, and fever. That he did inform Dr. Bernstein that he had taken a Tylenol like shortly before his examination.
I thought he indicated that there had been no vomiting that day.
Excuse me, Your Honor?
I thought he indicated that there had been no vomiting that day.
Well, this is an unfortunate sequence. When the plaintiff presented to Dr. Bernstein on May 15th, his health and life were salvageable. He did report and complain of symptoms that are consistent with bacterial meningitis. It was also known to Dr. Bernstein, this is another departure, that the plaintiff decedent was HIV positive and had been congenital.
Your expert says that the decedent was suffering from nausea on May 15th when he presented to Dr. Bernstein. Where in the record does it show that the decedent was suffering from nausea on May 15th?
I'm sorry, Your Honor, I do have.
Where in the record does it show that the decedent was suffering from nausea on May 15th?
That would be in deposition testimony. It would be he complaining of nausea.
Do you have a page reference where there's evidence that the decedent was suffering from nausea on May 15th?
The window of the defendant's departures started on the morning of May 15th, continued throughout May 16th, and continued through part of the day on the 17th.
When he comes to see Dr. Bernstein finds that he's got a normal temperature. He's not nauseous. He's able to communicate.
Correct.
His head can be rotated. How does your expert deal with all of that? What does your expert say about all of those findings by Dr. Bernstein?
If I may say, Dr. Bernstein concedes that once there was a positive strep test, he stopped considering possibility of an alternative diagnosis, and he also stopped thinking about conducting additional diagnostic testing.
Well, there's many infectious diseases that someone who's HIV positive might be more subject to than someone else. I mean,
Dr. Bernstein
how many
knew
of, how many of those diseases was Dr. Bernstein supposed to test for in order to have his medical care be regarded as being appropriate?
Your Honor, the appropriate test for bacterial meningitis, to which the doctor should have known that the decedent was more susceptible to HIV, include spinal tap, CAT scan, and blood culture, none of which were done. All went out the window because of a positive strep test. The decedent, unfortunately, was just prescribed Z-Pak, Zithromax, which didn't do him any good.
Okay, thank you very much.
Thank you, Your Honors.
We'll hear from the respondent. Good afternoon.
Good afternoon. May it please the court. David Bloom, Kaufman, Borges, and Ryan for the defendant respondent, Dr. Bernstein and Montefiore.
Counsel, the doctor was the long-term treating physician of the decedent?
That's correct.
And so he was aware of his HIV status?
That is correct.
And yet, when he presented with these various symptoms, he didn't take that into consideration that there could be something else which people with HIV are more susceptible to. He didn't do any testing for anything beyond that sore throat issue.
Well, I would respectfully disagree with that assessment. He did, in fact, consider a wide range of possibilities as to the source of the infection. The ultimate fatal flaw in the plaintiff's expert proof is that the expert offers no explanation, no discussion whatsoever for why the reliance on the positive strep test was inherently unreliable or unreasonable.
Well, was there anything that, that your expert saw that would have given Dr. Bernstein a reason to have considered meningitis? The plaintiff's expert says Dr. Bernstein testified he had no concerns of meningitis as a result of this examination. What was there, if anything, that should have given Dr. Bernstein this concern? I mean, there's a lot of infections that someone could have. Why should he have seen this meningitis?
Well, I think the most telling sign or symptom would have been an altered mental state. I think there's no disagreement about that as a common symptom or sign of meningitis. Here, the patient was at his baseline. All right, it's clear that that his physician had treated him for years, practically his entire life. And
I mean, so the fact that he knew him for so long, of course he knew that he was HIV positive. That's why he'd been treating him for 30, 40 years. But he also would be able to recognize, perhaps better than other people would, if he had something out of the ordinary that would concern him.
that is correct, and I would add to that, the evidence shows that Dr. Bernstein went above and beyond by testing or examining his sinuses, which was, there were no abnormalities there. He examined, his neurological state, his mental status. The only complaint at the time of that thorough examination was a sore throat, all right?
Which is explained by a positive stress test.
That is correct.
Well, was that the only complaint? Because I'm looking at the records here now, and it says that he complained of a fever of 102, informed the doctor that he had taken Tylenol, 2 Tylenols at 2 a.m., that he had chills, fatigue, had ear discomfort, headache, cold. The headache was rated 4 out of 5. Let's see what else. And loss of appetite.
Correct. That was the report made by the patient as having a history of those symptoms leading up to the examination. But the fact of the matter is that at the time of the examination, it is unrefuted that the patient was afebrile, his heart rate was normal, his vitals were normal, and most importantly, he did not have an altered mental status, which...
But
is that the only indication? So in other words, what you're saying is that absent the altered mental status, there was no reason to check for anything else.
After a positive strep test, absent any explanation for why relying on the positive strep test was in any way unreasonable.
So the positive strep test, in your mind, that takes care of the headache, that takes care of the loss of appetite, it takes care of all his symptoms.
I would disagree because at the time of that examination, the only symptom he had at that presentation was this sore throat.
So if a patient complains about something in the morning, earlier on that day, and doesn't present with those symptoms when he's being examined by the doctor, so you blow them off?
Well, it certainly doesn't warrant a spinal tap after a positive
I'm not suggesting that, but what about a blood test that he considered?
Well, okay, that's an interesting point, Your Honor, because the blood testing, which the plaintiff's expert made a huge point about, it is unrefuted that it would have taken 24 to 48 hours to get the results of that. Here, the outcome of this case would not have changed because the patient presented to the hospital the next day after his condition worsened. So it would not have mattered had the blood testing and cultures been done on the morning of May 15th. If there are no other questions, I'll be happy to rest, and I would ask that the order granting summary judgment be affirmed.
Okay, thank you. Thank you both. We will certainly take another look at these records. Thank you. The next case for argument is Prismatic Development versus New York City Transit Authority.
Good afternoon, Your Honors. If it please the Court, Patrick J. Green, Jr. from the law firm of Picard and Abramson, on behalf of the plaintiff, Prismatic Development Corporation. This case is probably not a run-of-the-mill case as would come before this court.
So, counsel, if I may, everything that I saw in the Constantino report said this is but a preliminary report. More work has to be done to investigate what the actual depth that would be appropriate for the piling is.
Yes, Your Honor.
For the boring. And I see, the documents appear to present all types of caveats, further caveats. The fact that this is the border of, this is on the edge of Staten Island, you have silty soil. Once you go before 40 feet, the soil grades change from soft and silty clay to denser tills, but even there, you have a wide variety of sizes. And then once you get to 75 to 100 feet below the ground, then finally you reach the area where there's no soft zones. So under taking those observations into consideration and all the caveats that permeate the documents, how does the plaintiff arrive at the conclusion that a 40 to 60 foot pile length is properly assumed? I don't get it.
Your Honor, that's a wonderful question. The fact of the matter is, in this particular case, the documents you're talking about were interpreted by a world-class geotechnical firm who was hired as a consultant walking in. I'm not going to purport to explain how that world-class geotechnical consultant came to its conclusions. But I will say this. I don't think those caveats affect the result in this case. And let me explain why. This is a more modern, as it were, contracting method than has been used in the past. This was a design, build contract.
But let's remember, in order for you to get relief from us, the burden that you have, this is an Article 78 proceeding after all. So the chief engineer, who's the one who's making the determination, he's the arbiter, he comes to the conclusion that the New York City Transit Authority claimed that what the Constantino report says and what the MRCE report says are not necessarily in conflict, because the Constantino report spoke of some clay, which could mean 20 to 35% clay. So how is that an arbitrary and irrational determination to make?
Well, again, I'm coming back to the contract because the contract was ignored by the chief engineer. The chief engineer as arbiter, that contract provision was accepted by the Court of Appeals in Westinghouse based upon the idea that there'd be a robust judicial review of a decision by a chief engineer. The chief engineer in this case failed to reconcile his decision with the primary contract documents. In fact, he ignored them. He didn't mention them. The trial court did not mention those contract provisions. Even now, NYCTA, the respondent, in its brief, doesn't try to reconcile the contract documents. I will point out, the contract, the primary contract document, appears at Appendix A59. And at Appendix A60, excuse me, defines the contract documents. The contract documents as defined include the contractor's final, fully conformed proposal as accepted by the authority, and the authority's request for best and final proposal dated November 4th. The authority accepted the MRCE interpretation of the conditions. I'll say that again. In the contract, New York City Transit accepted Musa Rutledge's conclusions as to the 60-foot pile.
So, counsel, I'm going to twist a little bit what you're saying, because the contract also had a differing site conditions clause.
Correct, and I'll go back to that.
Let's talk about that a minute, because there was an understanding that the conditions might vary from what the preliminary report showed, and therefore there was a protocol set up, which, as you say, ultimately ends up in the hands of the chief engineer. But what happened here? What happened here that the MRCE logs were provided to the transit authority, but there's no notification in March, there's testing in March to May of 2018, but then there's no notification to the TA that there's actually differing site conditions. Isn't that the problem here in this case?
Well, you've gone to the secondary ruling. I think the primary issue, and I'll address your question in responding to this, the differing site condition clause says specifically, contractors entitled to relief for latent physical conditions at the site materially differing from those indicated in the contract documents. The definition of contract documents appears at Appendix A60 in the agreement. Okay? By definition, that includes the proposal.
You can finish your answer.
Okay. That, by definition, included the contractor's proposal and the contract price. New York City Transit Authority got the benefit of the contractor's interpretation and a cheaper price for the piles. When the contractor's interpretation didn't pan out, and he spends $2 or $3 million more, under the differing site conditions clause, he's entitled to additional compensation. That saves the authority money in the long run, because otherwise, every contractor who comes along is going to have to bump up his price by $2, $3, $4 million. And in fact, that's exactly what the engineer said Prismatic should have done. It's completely contrary to policy, completely contrary to the contract, and completely inconsistent with this contract's language, which were ignored below. Thank you.
Okay, thank you. You'll have a few minutes in rebuttal. We'll listen to the respondent. Thank you so much.
Good afternoon, Your Honor. It's Lily Abramchayev, New York City Transit Authority. I'm Assistant General Counsel. I will address...
Counsel, could you put the mic move it over? Thank you.
Is this better? Okay. Prismatic makes an issue of our acceptance of their proposal and saying that the contract documents that should have been reviewed by the chief engineer include Prismatic's price proposal and the technical specifications. The difficulty with that argument is that those documents, they are contract documents, undisputed, but they are not the ones that indicate the site conditions. They interpret the site conditions. The contract document that indicates site conditions is the Constantino report in the attachment, which includes the shear test velocity. So that's the document that has the indications. That's the baseline document, which something that all proposers had access to, and what Prismatic had to use to develop its technical specifications and the price schedule. So there is a difference between indicating and interpreting. The chief engineer determined that the interpretation was incorrect because the Constantino report did discuss piles going below 75 feet and below 100 feet. The piles that Prismatic proposed didn't go past 60 feet. Now, is that something that was completely blindsiding to Prismatic? Absolutely not. Constantino report devoted significant amount of time discussing the depth. We specifically commissioned a geotechnical consultant to perform a test to ascertain how the soil behaves below 75 feet. There was an anticipation that the piles will have to go that deep given the soil conditions. In fact, our preliminary designs indicated longer piles. We indicated steel piles filled with grout. That was our suggestion. Prismatic didn't hit this suggestion as that was their right. They are the designer. They proposed a different design, which we accepted. Now, what does acceptance mean? Under Article 802 of the contract, acceptance means absence of an objection. For us to perform a very detailed review of any submittal would be impossible because it would require us to ascertain the load, ascertain the type of structure, ascertain the type of piles, the number of piles, the spacing of the piles. It's not something the authority is equipped to do. It's not how the contract is structured. We hire a designer to perform this work. In this case, it was Prismatic. We bought their design product. The design product was faulty. Now, on the standard of review, Prismatic makes an argument citing federal cases that this has to be a de novo review. May very well be in federal courts where they review the government decisions on the de novo basis. This is not the case. This is an Article 78 proceeding. The chief engineer's decision was rational. It was upheld by the Supreme Court, and it should be affirmed here. Thank you.
Thank you very much.
Thank you.
Allow me to briefly address this issue with respect to Article 802. I think the authority argues the contract incorrectly in many respects, but this is a particularly egregious error. You have the bid process. During the bid process, during the contract formation process, the parties agree to certain things. And in this contract formation process, as evidenced by the contract, they agreed to a price for 60-foot piles. The contract further provides that after the contract is signed, Prismatic's going to complete the design. The agency, in this case the authority, is permitted to review that design before it's implemented. 802 applies to that process, the design after contract. It's got nothing to do with the contract formation issues. And as such, it's completely misused and misstated by the authority. The authority did have an obligation, or right, I'm sorry, to review Prismatic's proposal to make sure it complies. I take that back, I'm sorry, that was a misstatement. They had the right to review Prismatic's design submittals after contract to make sure they complied with the contract. That right doesn't create a right in the authority to demand more than what it contracted for without paying for it.
So you're saying that the TA made a mistake by not requiring boring below 75 feet?
No, I'm not saying
that falls on the defendant?
No, I'm not saying that at all. I'm not criticizing the agency's pre-bid investigation process. They did what they did. It was what it was. We both had it. What I'm saying here is, based upon that information, we both agreed, both parties agreed, that 60-foot piles should work, and a price would be based upon that assumption. That assumption didn't come through under the terms of the contract that requires additional compensation.
Didn't the Constantino report contemplate that the pilings would have to go to 75 to 100 feet down?
Which Constantino, Your Honor, again, I'm not standing here trying to interpret these provisions that were these engineering reports that were interpreted by experts. Mr. Rutledge was hired during the bid process. The parties agreed to specific design parameters. They both had the same expectation. The authority accepted the lower price that comes with 60-foot piles. And by the way this agreement's written, agreed that if that doesn't happen, okay, we'll pay then. That prevents the authority from having to pay for 70-foot piles.
So what you're saying is that from the get-go, the authority knew we're going to be paying more than this?
Well, the authority explicitly agreed to it. That's my point here. They explicitly agreed to 60-foot piles.
They took this price knowing there's no way we're not getting it for this price because there's definitely going to need to be more.
I don't know that they had any thought whether they have to pay more or not. They agreed to the 60 feet. If it works,
but isn't that what you're telling us?
I'm not sure, Your Honor. I'm telling you, and let me clarify.
You're saying that they agreed to 60, but everyone knew from the get-go that it's going to have to be more.
I don't think that's the case. I don't think there's any facts in the record that support that conclusion, Your Honor. And I can tell you that a world-class geological consultant reached a conclusion different from that at the time Prismatic was bidding the contract. I'm not,
Okay, I know your time is up, but I just want to ask you, you received the MRCE report on March 12, 2018, and yet no letter goes to the TA until September 14th, 2018. What's the reason, what's your explanation for that delay?
Well, I think actually, first of all, the report that we got in March was given to the authority. So we were both operating on the same level of information. Nothing was withheld. And at that point in time, the party, Prismatic, had not in fact concluded that 60-foot piles wouldn't work. We became aware certainly that they wouldn't work after a test pile program, when they tried to drive 60-foot piles and they didn't reach.
So you mean you're saying you didn't know this in March?
They did not know that the 60-foot would not work in March. That's correct. But nonetheless, Your Honor, they provided the information to the authority, which is everything that the differing site condition clause requires. They didn't hold it back.
Okay, thank you very much. We'll take another look at these papers. Thank you both.
Thank you, Your Honor.
The next case.
And let me thank the panel for the extra couple of minutes.
No problem. We'll next hear from ACC Construction versus Merchants Mutual. Good afternoon.
Good afternoon. May it please the court, Sim Shapiro, law firm Baxter, Smith & Shapiro, on behalf of the defendants' appellants. I think as an initial matter, it's critical to note that the angle from which this appeal should be seen, which is this is not a case where ACC tendered and is now seeking the coverage. That tender was already accepted by Liberty, which was the insurer for the plaintiff's employer, Godsell, the third-party defendant in the underlying action. So here what we have is Liberty actually seeking to push off its coverage onto another insurer. That said, ACC's liability is certainly an issue in this case.
Well, Liberty is not even a party to this case.
Yes, and that is an issue because, of course, they're the real party in interest here, and they're not named. So that was an issue we brought up in our brief.
Why didn't you name them? So why didn't you bring them in?
If the issue is would we third-party them in, I think the issue really is why didn't the plaintiff bring them in? I don't know that third-party action to name
Well,
the
maybe
insurer.
they didn't want to bring a declaratory judgment action against the insurance company that was actually defending them in the underlying action. I mean, they didn't need to bring a case to declare that they should defend because they are defending them.
That's correct. I'm not suggesting that they should have sued Liberty, but I am suggesting that Liberty should have been a plaintiff because let's face it, who's actually paid the bills here? Respectfully, I don't think it's the plaintiffs here, it's Liberty. Liberty's the one that's been paying for their fees in the underlying action, and Liberty is, as a term we've used in the context of anti-subrogation, the real party in interest here.
Look, there's a basis to say that Liberty is a co-insurer, but how does recognizing that affect what should happen here? I mean, maybe you want to say you're missing a necessary party?
Yes.
You could have done something about that too.
I think that to bring in a third-party action, essentially seeking to name them, I don't know that that would be the appropriate approach, but I do agree that that's not the primary issue in this appeal. So it is a point in our brief, which is that they weren't named by the plaintiffs, and they are, in fact, the plaintiff, but that's not the primary issue in the appeal. I do think the primary issue in appeal here is, and why it's relevant that Liberty should be here, is, in fact, the Liberty policy vis-a-vis the merchant's policy. And here what you have is you have two contracts that are essentially identical. You have two very similar additional insured clauses in the respective policies.
And both of these, they're both representing electric companies. Right?
Correct. One, though, Liberty is, in fact, they're insured as the employer of the plaintiff.
That's right.
So I think at the very least what you have here is co-insurance. The idea of Liberty saying, no, it should all be on them.
There's not, I mean, we're not going to grant co-insurance in this case. Did anybody seek that relief in this case with Liberty's not a party?
They didn't, and that's one of our issues, which is, and they really hardly even discussed, frankly, the layers of coverage. You'll see there's a short reference to it on page 157 of your record in the court below. There's very little discussion of, okay, let's say ACC is an additional insured on your policy, and I'll speak for a moment about that in a minute. Whose coverage is primary, or is there co-insurance? There's very little comparison of the two additional insured provisions, which is of course critical, because if in fact they're identical, you'd have a co-insurance situation. That wasn't really part of the relief that was sought by the plaintiff in this action.
Because Liberty's not a party to this case. Let me ask you, what about the fact that there is a contract that requires this additional insured coverage, but aren't you claiming that that not all of the plaintiffs are entitled to the additional insured coverage because you only have a contract with ACC?
Absolutely, and under Gilbane, since they weren't the parties to the contract, they wouldn't necessarily be entitled to additional insured coverage anyway. Above and beyond that, I'll point out, I respectfully submit that in contrast to Godsell, which is the Liberty insured here,
Right.
and this is a case that, Your Honor, Justice Kaepernick, you were on the panel there, in the underlying action, there's still an issue of fact as to whether ACC, the plaintiff in this action, is the at-fault party. And if they are, of course, under Burlington, they wouldn't be entitled to coverage at all. And I know my colleague says, oh, no, Burlington only applies to the duty to indemnify. Burlington doesn't say that. I cited a case from Judge Cave in federal court that does it. It applies to quote-unquote coverage. So if, for example, and this is just one basis, but if, for example, if ACC, the plaintiff here, is found to be the 100% at-fault party in the underlying action, they wouldn't be entitled to additional insured coverage at all under the merchant's policy.
But the court below found that, or did they not, that the termination of plaintiff's entitlement to indemnification from your company is held in abeyance pending the outcome of the underlying
Yes.
because we know.
Yes, the court, they were not granted summary judgment on the duty to indemnify, and they did not appeal. Only I appealed. But what I am saying is in the underlying action of Hammer, which is the plaintiff, the personal injury case.
Right, PRK.
And that's a case from earlier this year. And in that case, this court, and again, Your Honor, Justice Kaepernick, you were on the panel on that case, this court reversed the lower court in that underlying action and held that there are issues of fact as to the culpability of ACC. In other words, they're not just the general contractor, they might have been actively negligent. And in fact, the plaintiff's claims pursuant to labor law section 200 were reinstated. And in fact, they were not found to be not necessarily entitled at this point to contractual or common law indemnity from my client. So if that's the case, and in fact, ultimately, for example, a jury decides, look, ACC Construction is 100% at fault. Under Burlington, they wouldn't be entitled to coverage at all because of the language of the additional insured endorsement in this case. And I do see the red light on, so I'll...
All right, you have a couple minutes on rebuttal, so why don't we hear from respondent? Thank you.
Good afternoon, Your Honors. May it please the court. George Cornell from the law firm Cornell Grace.
So I got to ask, I mean, having listened to this argument from merchants, why do we not have liberty in this lawsuit officially? I mean, he's saying you're represented by Liberty, but why aren't they officially a party in here to determine this issue about primary insurance or co-insurance? I mean, I know they're defending you in the lawsuit below, but you're asking them to defend you on the lawsuit below. So if the court said yes and we agree, then who's going to defend you in the court below? Now, then they're going to have another lawsuit about who's primary. They're not going to work that out either?
Yes, thank you, Your Honor. It's a good point, and just to be very clear, we don't represent Liberty in this matter. We, as it's already been established, we filed a third-party complaint in the underlying action against the employer. The employer, Godsell's insurer, is Liberty.
Okay.
Liberty then picked up our tender under a reservation of rights.
Picked up your that's what I mean.
We have no ability to bring Liberty into this declaratory judgment action because we don't represent Liberty at all. They're their own.
Wait, if you don't, yeah, but couldn't you bring them in as a respondent in this case or a defendant in this case?
As Your Honor mentioned, they are defending us in this case, so we don't want to get in a situation where possibly they won't be defending us anymore.
You don't really care about it because you want to throw this over to merchants.
Sorry, Your Honor?
You don't really care about Liberty. They're defending you is one thing. And besides that, it's your position that this should be merchants' responsibility.
Your Honor,
so you have no reason. So you have, even if it wasn't that they were defending you, you would also have no reason to bring them in.
So, Your Honor, ACC is the construction manager of this case. We entered into many contracts. There's a lot of liability here. We entered into contracts where a lot of different entities owed us insurance coverage, including the entities
here. But your agreement with Premier requires Premier, your agreement with Premier required Premier to make you an additional insured on their policy.
Correct.
And that's what you're seeking to enforce.
We are, and we're seeking to enforce.
And you don't particularly care, and that means merchants, and you don't care about Liberty.
Well, we do still care about liberty, and respectfully, we don't believe that there's anything stopping us from getting a judgment that we are additional insureds under both with Premier and their insurer, and as well as Godsell and their insurer.
Because we don't know what's going to happen with the liability down the road.
Exactly. This is a construction accident. As I'm sure your honors are aware, these verdicts go into the multi-millions. I believe the Godsell policy with Liberty is a $1 million policy. I could be wrong, but I believe it's about that. And it's almost definitely going to go above that. So we're doing everything we can to protect our client. And in that case, it's going after all the possible risk transfer options that we had available to us. One of those was tendering to Premier and having merchants also come in and defend us.
I mean, just out of curiosity, so if we affirm the finding that that they should, that you're an additional insured on the policy, then you go back to the personal injury case. Who's going to defend you? Both of them, or then there could be another lawsuit?
I believe, Your Honor, that would have to be worked out between them.
Merchants and Liberty.
Yes, unless, of course, you order today that Liberty has to primarily and non-contributorily defend us. I believe in that case.
But wouldn't that be difficult because they're not in this lawsuit? How can we make a determination about what Liberty should do if they're not even in the lawsuit?
I think, again, as you mentioned, that's something that would have to be worked out in another case, but I would submit that was not on us to bring in, or as I said, we can't force Liberty to be a plaintiff with us.
But for now, it's your position that based upon Hammer's allegations in the underlying suit, you're entitled to a defense from merchants and also indemnity, which could change depending on what turns out as Hammer's case goes forward.
That's correct.
And do you think that there's any kind of problem with, in additional to ACC, should 377th Avenue and ComScore also be entitled to be additional insured because they don't have a direct contract like you do with Premier?
Thank you for bringing up that, Your Honor. And one point that was not discussed was that the lower court below also found that ComScore and 370 are afforded contractual indemnity to their defense as of now in the underlying action. The court specifically said that contractual indemnification is afforded for the defense. However, I'm not going to make a decision on the ultimate indemnification obligations. So we would actually argue that we're also afforded the primary insurance because this other insurance clause issue does not speak to the contractual indemnification issue under the policy. It only speaks to the additional insured issue. So it's our position that that merchants here does have to defend us. Also, I know it wasn't asked, but counsel says that we didn't satisfy our burden. The burden for additional insured coverage for the duty to defend is that the allegations in the underlying complaint broadly assert that there is negligence against the named insured. We have that here unequivocally. There's no question. The case law is squarely in our favor. As for these other issues, I would respectfully state that there could be another lawsuit to deal with those issues. I don't think that it was our responsibility to bring in our additional insured coverage insurer in this action. And I would say that Liberty is therefore required to defend us primarily in this underlying lawsuit.
Do you mean Liberty or Merchant?
I'm sorry, I meant merchants.
You see, even you're confused. It's your case.
I apologize. I meant merchants.
You thought I wasn't listening.
Yes, obviously you are. Merchants is required to defend us primarily. Thank you, Your Honor.
Okay, thank you.
Good afternoon again. Just very briefly, I think the problem here is that if, in fact, it was just a declaratory judgment action about the plaintiff being an additional insured in the merchant's policy, we'd be in a different place. But they actually sought primary coverage, and in fact, the court below actually granted them the primary coverage. So to just stop and saying, okay, well, we feel you're an additional insured on the merchant's policy, this court would at the very least have to reverse that part of the decision of the court below, because if you look on page 22 of the record, Justice James held that the coverage for merchants was primary. And in fact, in the record that we have here is also the Liberty policy. So respectfully, this court should not just stop at saying, oh, well, you're an additional insured on the merchant's policy, because the court below went further than that, and that needs to be addressed. Also, Your Honor, Justice Friedman had asked, well, why didn't you just bring in Liberty? I should point out, aside from the fact that this was plaintiff's burden on this motion, and that obviously also includes showing the primary coverage, They made that motion very, very early in this declaratory judgment action. And in fact, one of my arguments had been, look, we haven't done depositions, we haven't done discovery, you didn't attach any deposition transcripts to your record. So that may very well be an appropriate issue. But in fact, one of the problems here was this motion was made so early in this declaratory judgment action. Lastly, I'm not sure I even followed the discussion just a moment ago about contractual indemnity versus defense vis-a-vis the plaintiffs in this action. I do want to point out contractual indemnity are claims that they brought in the underlying action, although they've also referenced it here. Again, that's another problem we have, is we have similar claims in both actions by the plaintiff here. But again, in that decision, the underlying action, the plaintiffs were denied summary judgment on their contractual and common law indemnity claims. They're not entitled, no court has found at this point that they're entitled to contractual indemnity at this point from my client Premier. And that's an issue yet to be decided. And again, that of course all weighs in favor of why summary judgment should not have been granted in this case. Thank you.
Okay, well, we'll see if we can unravel this one. Thank you both very much. The next case for oral argument is Samuelson versus Woolman Rink. And you represent Woolman Rink, correct?
Yes, Your Honor.
Okay. You may proceed.
May it please the court, my name is John Sandercock, and I represent the Rink defendants. Your Honors, the motion court's order should be reversed, and the Rink defendant should have summary judgment because the plaintiff assumed the risk of falling on the ice.
Counsel, at the time the plaintiff fell, she was no longer skating on the ice. She was in fact she had exited the ice and was walking towards a ramp.
She was just exiting the ice.
Was she just exited or had she exited? There was testimony or a eyewitness saying that her feet were both outside of the ice, correct?
She had taken 2 steps onto the ramp.
With both feet or with 1 foot?
I believe with both feet.
Okay.
But I'm not positive that that's clear. But we know that she stepped over the edge of the mat and was on the ramp when she fell. And she fell backwards toward the ice. Your Honors, the assumption of the risk doctrine applies not only to the surface of the rink, but also to any open and obvious condition of the place where the activity is carried on. This comes from the Maddox decision in the Court of Appeals.
But the thing is, this was not part of the main rink. She was stepping off of the rink. So it's not where the ice skating is actually going on. It's the exit or entrance to, it's a ramp, a rubber ramp, right, leading off of the ice. So she was finished with sport and was leaving.
It was a flat surface immediately adjacent to the rink that you had to step on to leave the rink.
The cases that you cite in your brief, Saravia, Rossman, those involve the actual skating surface, right? Those were accidents. A puddle was on one surface. That's not what happened here. She was outside of the rink.
Yes. Yeah, most of the cases do involve people skating on the ice itself because they involve collisions between skaters or people just falling.
But then we're talking about a difference between night and day, right? The difference between a sport and the assumption of risk when you take on certain sports and walking on a ramp.
Well,
which is provided for and maintained by the defendants in this instance.
Well, Your Honor, as cases have held, the plaintiff had her skates on. She was still participating in the act of skating.
How? Because she had ice skates on?
Because she had to leave the rink.
So I'm on a horse, I get off the horse, I'm still participating in equestrian activity?
Yes, absolutely. There's a
I'm on a bike, I get off a bike, I'm still participating in the sport of cycling?
Certainly. Yeah, there's a case in the 4th Department involving a high school student who was injured in a locker room because someone with skates on stepped on his foot. There's a new case from the 3rd Department involving a snowboarder.
So you're moving, you want us to move away from the maintenance of the matting and the conditions of the matting, and solely look at the fact that this particular plaintiff was ice skating and had left the rink. And so what about that?
Well, turning to the issue of maintenance, the plaintiff and her witnesses do not know what caused her to fall, so they can't show the proximate cause.
They all talked about, they talked about ice on the mat. They talked about lumpy matting.
Yeah.
Two of the witnesses made complaints. They talked about the installer of the mat said, sure, mats can lift up and peak, which was a surprise to read. What do you have to say about all of that?
The plaintiff has witnesses, the plaintiff has witnesses who testified that she had stepped over the area where the mat was arguably raised. And no one had ever fallen there before. And no one had ever complained of it before, including the plaintiff, who said that she'd had no reason to complain.
Ms. Weatherby-Shulman and Ms. Eaton both testified that they had complained.
Well, Judge Eaton may have told several people that the ramp was slippery on occasion, but that's just a general awareness of a dangerous condition. That's not sufficient for constructive notice of the particular condition that caused the plaintiff to fall. But I see my time is up.
Okay, you'll have a few minutes on rebuttal, so
Thank you, Your
we'll
Honors.
hear from the other appellant, Classic Carpet, correct?
Yes, good afternoon, Your Honors. Thank you. Michael Beckler on behalf of Classic Carpet. I'm going to be very brief. I'm not going to get into the assumption of risk argument, although we made that in our papers as well. We sold mats to Classic many years before the accident, and the first argument is that plaintiff in their opposition papers came at us in terms of the Espinal argument. We never had a contract and with anybody in this case, so Espinal should not apply. It was not in the moving papers, so there should be no preservation of that argument at all. This court has general jurisdiction over it, if you can see that there should be an issue there. But here, there's absolutely no issue with regard to contracts. So the Espinal argument should be put aside. We would be called in, Classic, when the Trump, Wallman Ring people would say, come in, we've got a mat at a place, or at the end of the skating year, to come in and break down the mats, store them at Wallman Ring, and in the beginning of the year, which is usually sometime in September, excuse me, or October, to set them back up. They had a complete staff at Wallman Ring. They maintained the mats. They cleaned the mats.
But I mean, obviously you knew what the mats were being used for. They were being put on these exit/entrance way to the ice rink. And there was testimony from several people, I believe, that there was lumpy ice not only on top of the mats, but underneath the mats that made it unsteady. And if the ice got underneath the mats, they sometimes stayed lumpy for a long period of time.
Well, that's correct, Your Honor.
So how do you represent that the mats are okay for what you were giving them to the rink to be used for?
Well, Your Honor, these are interlocking rubber mats that are used in all the New York City school playgrounds. They're used
Exactly. So if they're interlocking rubber mats, how does your person say that, yes, they peak and they get lumpy?
Well, that's true to any heat, cold, expansion, contraction, rubber mat would pliable material. It's true.
Why, shouldn't there have been more insulation or more adhesive under those mats?
There
prevent
could be,
that?
but there could be, but that's not something that classic carpet would have anything to do with, Your Honor. That's something that the co-defendant who maintains the facility, who owns the facility would
But who installs the mats?
I'm sorry, Your Honor.
Who installs the mats?
Well, it's not a permanent installation, Your Honor. It's just something that's laid down. And sometimes classic carpet, sometimes Wallman Rink would just put them down and pick them up. Not classic. These are just interlocking mats that would be laid down on a yearly basis.
So,
it's not but I'll just say one more thing.
Wait, let me just ask this question so I can understand. Your argument is that once you have given these mats to Woolman Rink, you guys no longer have anything to do with it? Is that what it is?
That is true, and also, it's also not the installation that's being alleged to be the cause of the injury. The plaintiff has also said that there's some kind of piping and things underneath that's causing freezing, that's pushing these mats up from underneath. That's not a classic carpets issue.
But, and the thing is, I go back to what I said before, you're installing them, you know exactly what people are gonna do, they're gonna walk over them, walking onto the ice rink and off the ice rink, and you use the ice rink when it's cold outside and it's icy. So if you created a dangerous condition, which could have been a proximate cause of this accident when you installed the matting, I mean, you knew there was a refrigeration system underneath and that could have a cooling effect. I mean, you knew all these things when you put it there. So isn't that at least a claim? I mean, maybe you'll win a trial, but aren't those claims valid claims, at least for now?
It's an excellent question. We had no idea, there's nothing in the record that Classic Carpet had any idea of what was underneath the ramping system or anything that was underneath any of the area at Wallman Rink. They just were sold mats.
I don't understand this because we know that there's different products oftentimes for different uses.
I'm sorry, Your Honor, I'm having trouble understanding.
A lot of times there's different products for different uses, and there's indoors products, there's outdoors products, and this was an ice skating rink, and we know that when people walk on those ice skates, they're not exactly walking on the same surface as they would when they walk with shoes. Why is this case appropriate for dismissal against your client? I mean, why don't we have tribal issues here?
Well, I'll say one more thing. Your Honor, this is not a products liability case where we put a product in the stream of commerce where we could have that argument. This is a case of rubber interlocking mats, which is our Rockefeller Center. They were made in Montana, where it's for cold weather temperatures and are completely appropriate for cold outside temperatures.
But who's installing the mats?
Sometimes Wallman Rink installs it, sometimes we put it down, and they're broken up.
Who installed these mats?
Same thing. The testimony is sometimes by Dale Clyde, the Wallman Rink.
Did you install these mats?
We did it at times, and they'd break them down at times, Your Honor. They were.
I mean, you installed them, but maybe the ring picked them up and reinstalled them.
That's correct.
But initially, you installed them.
Right. Every year they were broken down and then reinstalled. They would put
By you?
Sometimes by us, sometimes by Wallman Rink.
But isn't that an issue that should survive for trial, to see who did it in this particular instance, and now that we have this case before us, right?
Well,
that's a triable issue.
Yeah, well, Your Honor.
Because you can't even tell us who did it. You're saying sometimes this, sometimes that.
Your Honor, I would agree 100% with you if there was an issue about installation. This is not an installation issue. This is an issue, there's a lot of issues with regard to whether a plaintiff can identify exactly what caused her to fall, but also she's claiming there's some kind of icy condition on top. That's a condition not by virtue of the product, but by virtue of who's maintaining it, and that was Wallman Rink, not Classic Carpet.
Okay, thank you very much. You'll have a minute for rebuttal. We'll hear from the plaintiff respondent.
Good afternoon, Anthony Macroft from Gross Swiss Legal and Corrick for the respondent. So the dispositive question in this case is whether the dangerous condition in question was inherent in the sport of ice skating, or if it was a defect that occurred in the regular course of maintenance and the defendant's maintenance. So on this record, I think it's clear that this was a defect that arose in the regular course of maintenance. General manager for Woolman testified himself that daily inspection mandated that employees would go to the ramp, inspect the rubber mats, specifically for ice conditions and to make sure that the mats were even, and to rectify the situation if needed. He even went to say that that's the first thing they're supposed to do in the morning. Those were their maintenance orders. They even had ice choppers that they would use to break up the ice, put it in a wheelbarrow, and to throw out onto a grassy area. There's nothing in this record to suggest that this is something that is common to ice skating rinks. This is exists in.
Counsel, why shouldn't classic carpets be let out of this case? When this is, as they indicate, it's not about an installation. They provided the mats. Woolman did with it what they wanted. Sometimes they put them down, sometimes they didn't. How do we look at classic carpets in the context of the plaintiff's claim?
So plaintiff's expert John Burley, in his affidavit, he avers that classic carpet should have known that based on the layout of the mats and the fact that there was a refrigeration system that wasn't doubly insulated, that ice could form on the other side of the mat, right? The mat where the patrons actually step on to exit, and ice could form in between the mats, it could form underneath the mats.
So they should have given them different mats, or isn't that an issue that goes directly to Wallman Rink as to their refrigeration system that's operating to cause that, to create that hazard?
The expert, Mr. Burley, he averred that they should have given them instructions. Classic carpet should have given Woolman instructions on how to maintain the ice and get rid of it, and to warn them that such a condition could exist.
Remember, this, as the counsel said, is not a products liability case. They sell you these mats, there's nothing inherently wrong with these mats, and then the skating rink picks them up, puts them down. How do they remain liable for what happens months or years after they sell these mats?
So under Espinal, they launched an instrument of harm by failing to warn Woolman that ice could be underneath the mats, in between the mats, and on top of the mats. And that's exactly.
They're supposed to warn Wallman what's going on in its skating rink?
Well, they have specialized knowledge in the area, so they should have warned them, and there's nothing in the record to suggest that they did.
But the ice that was caused here wasn't caused by the mats themselves. It was caused by a refrigeration system, correct?
It wasn't caused by the mats themselves. I would have to agree with that, Your Honor. But based on the layout of the map, they were interlocking mats like a jigsaw puzzle, I believe is the word that's used in the record. That lended itself for ice to form in between the mats and to make them uneven.
So that's your theory of classic carpet being in the case, that they had specialized knowledge of this? Is there anything in the record supporting that position?
It was their job to install mats at ice skating rinks.
Didn't one of plaintiff's expert engineers say that it's at least possible that the mat thickness should have been different and that would have not created such a dangerous condition? I mean, did he find that? So that would be something that might go towards liability on the part of Creative?
Right, Your Honor, I would agree with that.
Okay, let's hear from, thank you. Could we hear from Woolman Rink again? Any response you may have?
Your Honors, we don't know exactly why there was ice on the mat. The ice.
You want to keep classic carpet in the case. You want to keep, if you stay in the case, you want to keep classic carpet in the case, which of course is a sensible position for you. But what's the basis for keeping classic carpet in the case? Let's assume we decide to keep you in the case. Why should we also keep classic carpet in the case?
Only because classic carpet was responsible for installing the mats. And there may have been a defect in the mat. But actually, we think that the mat isn't the issue. The plaintiff stepped over the area on the mat where that the plaintiff has identified as a problem.
So you agree that Classic should be dismissed from the case? If the mats aren't the issue?
I'm not in a position to agree, but the mats are not really the issue, no. And with respect to assumption of the risk, the second department decided a case called Canavos. It's at 187 AD 3rd 730. It was decided last fall. A snowboarder stepped, had finished making 2 runs of the mountain, stepped off the mountain onto a gravel area and slipped on black ice. And the second department affirmed the order dismissing the complaint for assumption of the risk. This is so the activity that's subject to the assumption of the risk doctrine continues after the person is finished with the actual activity, but still on the premises. And there's numerous cases to that effect.
Okay, we'll
you.
take another look. Classic Carpet, you have a minute for rebuttal.
Very briefly, the question about Espinal that plaintiff brought up again, that should not be considered. It wasn't preserved in the lower court. It was never brought up in any of the motion papers. Lastly, from the installation time, whoever installed it, it was months after that this accident happened. Classic Carpet was never notified ever.
Did you ever go back once you came in at the beginning of the ice skating season and took care of the mats? Did you come back before they were taken up?
Not one time, Your Honor, was Classic between the time that the mats were installed up until plaintiff's accident, December 11th, was Classic ever there. In addition to that, Classic was never notified by Wallman Rink, the manager there, that there was ever, from the time that the mats were put there, and ever a problem with icy mats or any defect with the mats ever.
Any other questions? Okay, well, thank you all very much.
Thank you, Your
We'll
Honor.
certainly look through this a little bit more. The next case for argument is Olson.
Good afternoon, Your Honors. May it please the Court. Josh Rosencrans representing Johnson & Johnson. Your Honors, plaintiffs persuaded...
Before you get started, let me just ask you, do you know the status of the Nemeth case? As best as I could tell, the appeal was perfected in May of 2021. Does that appeal, as far as you know, remain pending?
It remains pending, Your Honor. We just checked today, and it's still not calendared.
I mean, it's just waiting for a calendar date.
Yes, Your Honor. So plaintiffs persuaded a jury to find J&J liable based upon the explosive allegation that baby powder is causing cancer. Now, plaintiffs achieved this...
In doing that, did they present expert testimony that there's something known as a type of asbestiform, which may or may not be asbestos, caused it, and it's your position that there's no scientific basis for that claim?
Yes, Your Honor. This was a 1-2 punch. The first punch was what you just said, Your Honor. A major flaw in this judgment is based upon the absurd proposition that you can win an asbestos case by redefining what is asbestos, and by defining as asbestos something that scientists and regulators define as not asbestos. Those expert opinions were inadmissible under Frye because they were not generally accepted, far from generally accepted. Now, this court can decide this appeal in one sentence. We agree with the New Jersey Appellate Division's thorough opinion in Lanzo, vacating a judgment against J&J on the ground that there is literally no science supporting plaintiffs' redefinition of asbestos.
It seems to me that might be going a little bit far. I mean, I looked through whatever I could look through here. And I don't know if I would say that there was absolutely no science. I mean, I'm sure you can attack some of the science that was used.
Your Honor, I'm sorry.
No, go ahead.
Your Honor, I will issue a challenge to my friend on the other side. Read to this court every statement from a scientist who says, I have conducted an experiment. I have done actual science, and I have found a linkage between what scientists call non-asbestos and cancer. It will not take long. He does not have a single one.
So you're saying that tremolite is not a causant, is that the right word, of asbestos? That tremolite is not asbestos?
That is correct, Your Honor. Tremolite, under certain geological circumstances, can become asbestos. That's about 1% of all deposits
That's
around
when it has
the
the
world.
long fibers, right?
I'm sorry, Your Honor.
When it has the long fibers?
Your Honor, what the expert regulators and the scientists all agree is that size alone is not what makes something asbestos. It has to be asbestiform, which is to say it is formed in those geological conditions that give the asbestos the particular physical properties that make it dangerous in the lungs.
Those particular physical properties would be long fibers?
No, Your Honor. Asbestos is long fibers, that is for sure. But that is not what makes them dangerous. What makes asbestos dangerous is what scientists call biodurability and tensile strength. They lodge in your lungs, and they cannot be dislodged. It's because of the geology in which they are formed that gives them those physical properties. Now, every major U.S. regulator charged with protecting our health has come to the conclusion that if it's not formed in the asbestiform so-called habit, those geological conditions.
And there were experts on both sides in this trial, of course.
There were experts on both sides of this trial, Your Honor, and what I'm saying is that the two experts on the other side conceded that they actually could not point to a scientific experiment that confirms their theory. They had a theory. What the U.S. regulators that are charged with protecting public health have concluded, based upon actual science, is that if it's not...
The FDA had issued a determination supporting you.
Yes, Your Honor. The FDA, EPA, OSHA, MSHA, NIOSH, the Congress of the United States all agree that if it's not formed in an asbestos environment, it is not treated as...
And what was the value, or what was the importance of whether or not these were found in bundles or not? And what does that have to do with the asbestos form?
Your Honor, it's marginally related in the following sense. The way you identify whether something is asbestos or not is not by looking at, oh, here's a fiber of a particular dimension, but by looking around it and seeing whether they are in bundles. And that, of course, is something that plaintiff's expert didn't do. But I have to underscore the prejudice here. It's manifest. It would have been very easy for a jury to conclude that J&J's talc did not have asbestos based upon the testing of tens of thousands of samples over 50 years.
So let's talk about the testing, if you would. So we have the 1969 J&J memo, which references tremolite, right? And it says that it would seem to be prudent to limit any possible content of tremolite. Am I saying it right, tremolite?
Yes, Your Honor.
Tremolite in our powder. So they don't distinguish between types of tremolite as you do. They simply talk about tremolite. And then, so that's one question that I have for you, which is what is the import of the J&J memo in the context of your presentation? And the second thing is the issue of testing and what is appropriate testing and what is inappropriate testing. What is testing that is adequate and what is testing that is inadequate? These issues were raised to the jury, and there was a finding, am I right, that the testing was, there was an allegation, was a claim that the testing was inadequate because you weren't really looking for the asbestos.
So, yes, Your Honor, and I'm very conscious that my time is waning, and
You can answer it, Judge.
I do want to make sure to get to the second in the 1-2 punch. But yes, of course, the 1969 memo, let's just, to level set this, it was 1969. There is a lot of science that has emerged since then, so a 1969 memo cannot prove that tremolite is in fact asbestos. But that memo doesn't say that tremolite is asbestos. That memo says, back in 1969, we don't totally understand what tremolite is all about. It may have some health consequences. It doesn't say cancer. So it's best to avoid.
It doesn't exactly say that in the quote that I read to you. It says it would seem to be prudent to limit any possible content of tremolite in our powder. It doesn't say what you just said.
No, Your Honor, it does say what I just...
Any content, any possible content.
Yes, right, but it does not link it to cancer, and it goes on to say the reason we want to do that is because you can have an uproar. People will say, oh my goodness, tremolite, and they don't understand what it is.
And it goes on to say the memo advises consultation with the law department to assess the defensibility of our position in the event J&J is sued.
Correct, Your Honor. So that's 1969. That is not a scientific study. It is not an experiment that says tremolite is asbestos. We're now in 2021, and every major regulator has confirmed that simply calling something tremolite or saying that is in fibers does not make it asbestos. I do want to get to the other keystone.
I know this is not scientifically or legally speaking a particularly valid point, but I just want to hear a response to it. I mean, you take a look at this case, and the plaintiff has come down with mesothelioma. And she says, well, she's been using talcum powder for all these years, and her child was using it to get this great exposure. It's like so easy to take the next step and say, oh yeah, it must have been caused by the asbestos in the talcum powder.
So yes, Your Honor, if I'm understanding the question correctly, that is exactly what plaintiffs are trying to do. I mean, millions of people are using Johnson & Johnson's baby powder, and they are not coming down with an epidemic of mesothelioma or cancer. So what plaintiffs have to do is demonstrate that their experts are supported by a general consensus. If I may just say a word about
I'll give you another minute. Yeah, go ahead.
Thank you, Your Honor. The other keystone of plaintiff's case was testimony from Dr. Longo. Now, Dr. Longo claimed to have found asbestos in decades-old bottles of talc, and he then used the extreme outlier bottle with the highest concentration and clear evidence of contamination for the nonsensical estimation of Ms. Olson's exposure, which is why other courts have lambasted this expert and his approach as junk science or pseudoscience. This testimony should never have gone to the jury because it failed the Court of Appeals Amaro test, requiring, quote, reasonable assurances of the identity and unchanged condition of the evidence. Every sealed container was negative. The ones that tested positive had all been opened when he received them, and they came mainly from eBay. For all he knew, they were sitting in attics for decades with asbestos insulation.
Did some of these show contamination from insulation in attics?
Your Honor.
Did some of these samples show contamination from insulation in attics?
Your Honor, 5 of these samples showed that there was contamination. 4 of them have had Richterite in it, which has never been associated. Plaintiff's expert agree.
7 out of the 10 museum bottles were positive, right?
Yes, Your Honor. If I can just finish the answer to Justice Friedman's question, and I'll turn to the museum bottles. So Richterite has been associated with attic insulation, but never with J&J Cosmetic talc. The museum bottles, That's 7 out of the 42 that he tested. They also don't have a chain of custody. Plaintiffs are trying to portray this as bottles coming off of an assembly line and going straight to the museum. But some of these bottles were donated. And the bottle that was used by this expert, the outlier bottle, was not a museum bottle, nor were the 18 bottles that this expert identified as having asbestos.
But didn't the bottles, they didn't have any markers of tampering, right? If they had been tampered with, they would have had markers of indicating such.
Your Honor, our argument is not necessarily that they were tampered with. I mean, what you just said, Your Honor, is like saying that because a sewer grill is welded shut for 40 years, no dust comes through. I mean, these holes are about the size of sewer holes compared to dimes when you talk about the size of asbestos fibers and these holes. And what we're saying is, without any chain of custody and without any understanding of where they have been, these fibers could have just fallen into these bottles. Bear in mind, every time you press a talc bottle, it bounces back and it sucks in things all around it. And that's all we're saying. There needs to be a reliable foundation.
But you're saying this was all junk science.
Your Honor, I am saying it is junk science. You don't take samples with no chain of custody and use them to supersede the results of tens of thousands of negative tests and the results of the ones where there is a chain of custody, where he took them off the shelf. And I realize...
Yeah, you know what, I'm going to ask you to stop for now. We'll give you a few minutes on rebuttal, and let's hear from the plaintiff. Thank you very much. Respondent.
May it please the court, Jerome Block from Levy-Konigsberg, representing Donna and Robert Olson. I first want to address directly, with citations to the record, Justice Friedman's first question about how asbestos was identified in this case. At record 7591 to 7592, Dr. Weber testified that he identified asbestos in J&J's talc products following the generally accepted method mandated by the EPA in the AHERA Asbestos in Schools statute. Justices, once a particle is confirmed as one of the 6 asbestos minerals, and tremolite is one of the main types of asbestos, it is asbestos under the EPA's method and Johnson & Johnson's own method, so long as the tremolite is in the shape of a fiber. And that is defined in both the EPA method and Johnson & Johnson's own method. And the requirement, this is not subjective, the requirement is that it must have roughly parallel sides, and it must be at least 5 times longer than it is wide. If it meets that test under the EPA and under J&J's own method, and you could see the testimony of Dr. Weber at 9437 to 9442 of the record, it is asbestos. If it's asbestos, it's asbestiform. You cannot have asbestos that is not asbestiform. Tremolite fibers are asbestos under the EPA method, under J&J's own method. J&J argues, well, wait a minute. You have to show tensile strength, flexibility, habit, how it grew in the ground. That is not in the EPA method. That is not in Johnson & Johnson's own method. And you could see that at 9437 to 42 of the record. Johnson & Johnson is asking us to prove something that's not even in the generally accepted method. I'll issue a challenge to Johnson & Johnson. On rebuttal, he should tell this court what is the generally accepted method for showing tensile strength or flexibility, because there's no method to do that with microscopic asbestos fibers. Also, justices, Dr. Weber properly identified fibrous tremolite fibers as asbestos. At 13407 of the record, Johnson & Johnson's own corporate representative, in response to my question, said, quote, fibrous tremolite is asbestos. 13407, their own corporate representative. Yet Johnson & Johnson appeals to this court saying fibrous tremolite is not asbestos? Again, justices, J&J's own test method defines fibrous tremolite, fibrous anthophyllite, fibrous actinolite, all types of asbestos that were found in Johnson's baby powder as asbestos. And I'm going to give record sites, 18,088 of the record. You'll see it says asbestos is defined as the fibrous form of tremolite and those other asbestos fiber types. So as to Johnson & Johnson's challenge to me to cite a study that non-asbestos minerals cause cancer, that is a complete red herring. No one testified and no one sought to prove or testify in this case that non-asbestos caused Mrs. Olson's mesothelioma. Dr. Finkelstein, a qualified medical doctor, Dr. Moline, a qualified medical doctor, both testified that asbestos caused Mrs. Olson's mesothelioma. So that's their defense. Their defense in the case was, no, this is all cleavage fragments. And then they tried to link that up by saying, oh, there's no study showing cleavage fragments cause cancer. But the jury resolved that dispute against Johnson & Johnson. They found that there was asbestos in the product and that caused Mrs. Olson's mesothelioma. Dr. Finkelstein, and I'll give more record sites, repeatedly testified without objection that there was asbestos in Johnson & Johnson's talc products, that this caused Mrs. Olson's mesothelioma, 10,078, 10,079 of the record. Dr. Finkelstein knows what asbestos is. He knows the disease it causes. He has published more than 50 epidemiology studies on asbestos, record at 10285. Justice Leibovitz also instructed the jury that they must find asbestos. The jury had to find asbestos to find for the plaintiff. Record at 17046 to 56. If you read Justice Leibovitz's instruction, the jury had to find asbestos, and they did. And they resolved that factual dispute against Johnson & Johnson. Yet Johnson & Johnson comes into this court looking to relitigate the factual dispute. The jury found it was asbestos, and it caused Mrs. Olson's mesothelioma. As to the containers.
Just as curiosity, because your adversary was indicating that some of these doctors should never have even been permitted to testify. So was this handled at the beginning? Was there a request for a FRI hearing? I know at some point Judge Leibovitz said, look, I'll let them testify and we don't need a FRI hearing. I think this is what he said, and I'll make rulings as they come up, question by question.
Sure. We called 2 medical causation experts. I already talked about Dr. Finkelstein. Right. With Dr. Moline, they certainly didn't request a FRI hearing either.
She testified.
Yeah, and Your Honor, I'll go one step further. At 9125 of the record, J&J sought to, and they successfully got excluded from the case, 100 adverse event reports showing mesothelioma in Johnson's baby powder users. And here's what they told the court to get that evidence excluded. At 9125, quote, then they have Dr. Moline saying that the certain amount of asbestos that the other experts believe is in the Johnson's baby powder, in her medical opinion, to a reasonable degree of medical certainty, is enough to cause mesothelioma. That could come in fine. Those were the words of Johnson & Johnson's trial counsel, that she can testify. And at that point, Dr. Longo and Dr. Weber had testified about the amount of asbestos in the baby powder. And they said at 9125 that Dr. Moline can give that testimony. As to Dr. Longo's testing and the charges that were made about contamination, Justice Leibovitz called that quote, J&J's speculation about the possibility of post-sale contamination of the bottles with asbestos fibers in the ambient air. That is at 65.15 of the record. Justice Leibovitz heard all these arguments, And he found that
Your adversary says that the test bottles were unreliable. What say you?
Sure. I'll give you a lot of reasons why they were reliable. Dr. Alice Blunt, their own litigation consultant, former litigation consultant, found tremolite asbestos, a unique type of asbestos, in Johnson's baby powder multiple times. Dr. Longo found that same type of asbestos. We showed documents that there was anthophyllite asbestos in Johnson's baby powder. For example, at 18595 to 98 of the record, you'll see a test report, anthophyllite asbestos in Johnson's baby powder. Well, guess what? Dr. Longo found that same type of asbestos. These are non-commercial types of asbestos, okay? So he found the unique types of asbestos that also match the asbestos that were in Johnson & Johnson's historical testing, and he found them in the bottles. And I would cite to you the case Ingham, the court in Ingham from the Missouri Court of Appeals, and we cite it in our brief, 608 Southwest 2nd, 701 to 704, found that Dr. Longo reliably assured that there was no tampering with the containers, and that these were issues of fact for the jury to resolve.
Can I switch your focus a sec?
Yes.
So would you kindly address the issue of punitive damages? Is it premised primarily on the testing issue, what you allege is the inadequate testing that was conducted, as in my layperson's parlance, MRIs versus X-rays, or was it more than that? Does it have to do with the emails? Why were punitive damages properly awarded in your view?
Justice Gonzalez, thank you for your question. I think that, in this case, one of the unique things is this panel has a 61-page post-trial decision from Justice Leibovitz that cites the evidence in the record. If I may have the same courtesy as...
Go ahead, you can finish your answer.
Thank you very much. Justice Leibovitz summarized the damages supporting punitive damages at 65.29 to 41 of the record. He goes through the evidence. Johnson & Johnson knew about the hazards of asbestos in the 1950s. They knew that the asbestos was in their talc. They purposely chose to use test methods that were inadequate, foregoing the use of more effective methods. J&J gave incomplete and misleading information to the FDA. This is in Justice Leibovitz's opinion. He cites the evidence, including misleading information in 1986 when the FDA made the finding that Justice Friedman referred to. Justice Leibovitz found that the evidence was, quote, sufficiently reckless and reprehensible to support the jury's decision to award punitive damages. And as the Court of Appeals has stated in the Nardelli case, the issue of how much punitive damages to award is an issue that resides primarily in the sound discretion of the jury and should not be lightly disturbed. The U.S. Supreme Court has said these cases have to be decided on their facts. Justice Leibovitz reduced the damages, so it's a 7-to-1 ratio. The court in State Farm said that single-digit multipliers will likely comport with due process. All the reprehensibility factors set forth by the U.S. Supreme Court are here. I want to quote from Justice Leibovitz. He presided over this trial. There's more than 10,000 pages of trial testimony. And Justice Leibovitz found sufficient evidence that, quote, J&J's pattern of premeditated, long-lasting, broad-ranging, and egregiously reprehensible conduct supported the punitive damages award. Justice Leibovitz reduced that award for punitive damages from $300 million to $105 million. If that punitive damages is reduced any further, it would thwart the deterrent purposes of punitive damages because the conduct was not only reprehensible, but it caused an incurable cancer, over 4 years of pain and suffering. And if this court were to reduce punitive damages more after they have been reduced so much, it would thwart the deterrent purposes of punitive damages in light of the reprehensibility of J&J's misconduct, in light of the enormous harm to the Olsons and the enormous wealth of the Johnson & Johnson defendants. Thank you for that extra time.
Thank you very much. Okay, Mr. Rosencrantz, you have 2 minutes.
Thank you, Your Honor. Just a few points. First, I still haven't heard a reference to a study, an experiment, an epidemiological study that says that all you have to worry about is the size of a fiber of a mineral, and that will define it as asbestos. That's not what the EPA does. Record 8266 to 69, the definition limits asbestos to, quote, asbestiform varieties of 6 minerals. That is exactly what the MSHA, what the FDA, what the Bureau of Mines, and what NIOSH does. And our brief provides sites for all of this. Second, and by the way, that is the regulatory consensus among agencies that are there to protect our health. Second, yes, the jury found asbestos. Lanzo addresses that. The jury will find asbestos if you redefine fibers to be asbestos just because they have a particular size. And as I was saying, the Lanzo court underscores that this was a redefinition of asbestos in a non-scientific way. Justice Gonzalez asked about the reliability of our testing, the testing of those tens and thousands of samples. There was an industry standard. It was a standard that the the FDA approved. We exceeded it using the most sensitive tests. And so that not only could that not be reprehensible, that is actually a legitimate way of measuring for asbestos. Plaintiffs keep referring to these historical documents, and this is important both for purposes of evaluating the Weber testimony that my friend on the other side underscored, and the punitive damages and harmless error. Plaintiffs have poured over 50 years of testing documents, including those tens of thousands of samples that were tested. If I just may finish.
Just finish your thought, yeah.
Plaintiffs cobbled together literally 26 documents, mainly from before 1975, that they characterize as positive or suspicious. Pages 18 to 19 and 37 of our brief debunk them all, but they all revolve back to that definition of asbestos because the vast majority of them don't find asbestos. They find tremolite or fibers, and those were not what we were defining asbestos to be or what anyone else has. If there are no further questions, I thank the court for its attention, and I request that this court reverse the judgment below.
Thank you both very much. Appreciate it. The next case for oral argument is Crimless versus City of New York. Okay, counsel for Bleecker Towers, you may proceed.
If it please the court, my name is Joe McGovern, and I'm very pleased to be here today on behalf of Bleecker Tower Tenants Corp. Court of Appeals in the Great Northern Insurance Company versus Interior Construction case recognized that a contract whereby Party A agrees to indemnify Party B, even for Party B's negligence, is enforceable and does not violate any public policy if that contractual promise to indemnify is coupled with a promise to purchase insurance and to have the other party named as an additional
What you're
insurer.
looking to do here is to put in a cross-claim against BRDY, is that right?
The motion that was denied sought leave to assert a
To amend the answer, to put that in.
Yes, Your Honor.
So the note of issue in this case was filed on January 29th, 2020. And it's 3 years since BRDY was added as a defendant. So how do you explain allowing all of this time to elapse without taking any action in that direction? And if we were to permit that, wouldn't BRDY be prejudiced in that it's too late for it to now go after Atrium which has been let out of the case?
My position is no, it would not cause any prejudice, because prejudice is the loss of some legal right, some significant legal right, or change of
So
position.
going after Atrium wouldn't be a significant legal right?
Well, BRDY,
Atrium's out of the case, right?
Atrium is out of the case at the same time that 644 BRDY is out of the case. If 644 BRDY was still in the case, it would still have its cross-claim against Atrium for contractual indemnification, which is a solid contractual indemnification.
That hasn't been dismissed? I mean, if you're allowed to go after BRDY, that automatically brings Atrium back into the case after it's been dismissed out?
Yes, as they contractually agreed to do, to indemnify their landlord.
That's already been decided, hasn't it? At this point, there's a decision on that issue, isn't it? Isn't there?
Well, there is a decision dismissing Atrium from the case. That's also up here on appeal today. Because I have claims against, my client has claims against Atrium. Both Atrium and 644 BRDY promised to indemnify Bleecker Tower Tenants Corp. Both contracts, both the master lease, the 99-year lease, and the sublease carry the contractual indemnification clauses and the insurance procurement clauses. They're both on the hook for obligations that they willingly, knowingly undertook.
Is there anything in any of these contracts that requires Atrium to do anything with the sidewalk? I thought they just kept, they were just responsible for the inside of their premises. How are they possibly going to be found negligent? I mean, I think the court below found that they couldn't be.
Yeah, the court below reasoned that if they couldn't be found negligent, then they couldn't be found liable for indemnification. But that's directly contrary to what the Court of Appeals ruled in the Great Northern Insurance case. So in Great Northern, they said, look, you can be liable for indemnification even if you're not negligent and even if you're indemnifying the negligent party. So the whole thing comes down to that risk shifting device in the contracts. Couple the indemnification clause with the contractual obligation to purchase insurance, name the party as an additional insured.
So, counsel, we agree that the overlease says that Bleecker is responsible for making any repairs to the sidewalk, right?
That would, I have no contest on that. That's yeah.
It is what it is. Your issue is that BRDY was supposed to indemnify you against any kind of case arising from the demise premises, the building, or the sidewalk.
Correct. Correct. Well, the accident arose or is in connection with, yeah, the crowded sidewalk, people going in and out of the building. So it's a very broad indemnification clause. It doesn't violate any public policy. It's bound by a consideration. And it was error for the court below to say that this was not a valid cause of action.
Okay, we'll hear from the other parties and you'll have an opportunity to respond.
Good afternoon. Good afternoon. My name is Evie Kazansky. Sorry about that. I represent BRD, is who you're calling it. First of all, there's a lot of little issues going on, so Justice Friedman hit on one of them, which was the timeliness of these cross-claim situation. We lay that all out, so I will leave that aside. The major issue here that we're really talking about—
If you came back into the case, if you came back into the case, if we were to permit that, would Atrium be back in?
Arguably, we have an indemnification claim against them. They're our sublessor, sublessee. So it would be 6 years from the time.
Wasn't it?
Excuse me?
That was dismissed, wasn't it?
It was dismissed in the context of us moving to dismiss all of the claims and cross-claims and counterclaims. We were eventually had our own suit against us. It's in the procedural process, so we have a direct claim from the plaintiff. That was clearly
But no
dismissed.
one's appealed from
With
no one's
respect,
appealed from the dismissal of Atrium.
plaintiff has not appealed anything. So with respect to a direct claim from plaintiff,
You certainly haven't appealed because you were let out with that too. I mean, no one's got an appeal here saying put Atrium back into the case, do they?
he's trying to get the Atrium.
He's trying, but he's trying by getting you back in.
The issues for us with respect to Atrium would be our lease, the same issue that they have with us. If we were back in the case, we could third-party them back in on a contractual indemnification and/or common law indemnification and procurement situation. So we have, those claims would be revived, we would argue, anyway, because the statute of limitations hasn't expired on them because we haven't even paid out on anything.
Right.
But more important is, I think we're missing the tree for the forest with respect to the indemnification issue. Even if we raise the issue that the indemnification clause is not enforceable because it doesn't carve out a negligence claim, and there is some issues with whether or not the insurance joined with the indemnification clause would fall under Great Northern. I'll leave that aside for a second also. The actual clause itself is in a conjunctive. We were an out-of-possession subtenant who subleased it. It's clear Atrium was in possession at the time. On page 257 of the record, it says that we're responsible to the landlord for in and about the demised premises, including the sidewalk, if it arising out of the tenant's use and occupation of the demised premises and the tenant's performance of covenants and conditions of the lease. If we don't have to be responsible for the sidewalks, then we didn't breach any covenant of the lease. And we also weren't in possession at the time of the accident. So what the issue with Great Northern is, even if it's enforceable, you still have to have the indemnification clause come under an enforceable act. And it's our position, and it was the lower court's position, which was correct, that there's no enforceable act under the indemnification. And then there were some other peripheral issues that I would just want to bring up that because the plaintiff didn't appeal, I would disregard the 7-210 argument completely. So as we said, we weren't in possession and we didn't breach any covenant. So since the indemnification clause is in the conjunctive, without those two conditions, the indemnification clause is not viable and we didn't breach anything. And therefore, we do not owe indemnification, and that's why the lower court properly denied the motion for the, to amend for the cross-claim. Thank you.
Thank you. Now, we have another respondent here. Good afternoon.
Murphy on behalf of the Atrium respondents. Bleecker BTTC is not a third-party beneficiary to the sublease between BRDY and Atrium. There is just simply absolutely no evidence within the sublease document that BTTC Bleecker was ever intended to be some kind of a third-party beneficiary to it. The only entity in the sublease defined as the owner is BRDY.
You're just called a sublessee. You're just called a sublessee.
Yeah, we're the sublessee. BRDY under the sublease is the owner. And when those parties negotiated to identify a definition for who BTTC is, in the sublease, they identified and defined BTTC as overlandlord. And BTTC, the defined identified overlandlord, has absolutely no rights vis-a-vis the sublessee in the sublease, none. The only reference to the overlease in the sublease is that Atrium got a copy of it, and that was for the surrounding provisions of the sublease that Atrium could protect itself, knowing what the responsibilities of BRDY were to BTTC, in the event that BRDY were to not meet its obligations to BTTC, Atrium would have knowledge and be able to protect its position.
You didn't
That's the
undertake
only
You
reference.
didn't undertake to indemnify Bleecker.
Absolutely not. The only indemnification runs in the direction of BRDY, and it's only in the event that there was a thing done, and Atrium did not do a thing, a breach of a condition of the sublease, and Atrium did not breach any condition of the sublease. All of the custom negotiated provisions of the sublease that deal with repair of sidewalks, they're in paragraphs 58 and 60 of the sublease. Those are the custom negotiated ones that would take precedence over any pre-printed form, vague things to the contrary, and both of them state explicitly, Atrium not responsible to repair sidewalks, Atrium not responsible to repair sidewalks. So we did not do a thing, we did not breach a sublease, and as the court below correctly found, we did not do anything negligent. Therefore, we don't owe any indemnification to Brady under the contract, under the sublease. They have abstract indemnification rights, but the facts don't support them, and we owe absolutely no contractual duties whatsoever to BTTC. Let's see, there was a mention in there in BTTC's reply brief about mutual or successive rights. There is nothing to support that. They have no mutual rights with BRDY. They're not partners with them. They have no successive rights from BRDY. They did not become the owners of the sublease agreement by assignment or anything of that nature. That argument holds no water at all. There's no incorporation by reference of the overlease into the sublease. I'm arguing from a vacuum of anything to support the notion, but if your honors have questions, I'll be glad to answer them. And I think for all the reasons that we've put into our brief, the order below should be affirmed.
Okay, thank you very much. Okay, counsel, you have 2 minutes.
Oh, counsel, I have a big question for you. So paragraph 6.12 has the indemnification clause, right? And that's where it says that BRDY is obligated to indemnify Bleecker for any damages or injuries occurring on the property, including without limitation, the sidewalk, elevator, or the sidewalks or curbs adjacent thereto. But then it continues. It doesn't stop there, and that's what was highlighted by your adversary. Then it says, arising out of BRDY's use and occupancy of the demised premises. So how do you respond to that? If there was no wrongdoing by BRDY because it in fact was not required to repair the sidewalk, then why is there a claim, or why is there ostensibly a claim against BRDY?
As my learned opponent pointed out, there is this language in the indemnification clause, but the language itself, arising out of the tenant's use and occupancy. Well, arising out of, as we discuss in our reply brief, is a very broad phrase, and it includes, it basically is connected with. So it's connected with their use and occupancy and their leasing of it, and it doesn't say breach
It
of the
doesn't say
covenants.
leasing, it says use and occupancy.
Use and occupancy, and tenant's performance of the covenants and the conditions of the lease. So you don't need a breach, you just need them performing what they said they were going to do in the lease, and then a connection with their occupancy and their subleasing of the ground floor, the basement, and the sub-basement. I would like to touch upon very briefly, because nobody has asked this.
30 seconds. What?
644 BRDY has dominion and control for 45 years. They're going to have dominion and control of this part of the property for the next 65 years. That is more than a life tenancy. This is an ownership interest, and every one of us went to law school. We all had to sit through 2 semesters of property law. And we know that there are different forms of property ownership: entail, fee tail, life estate, remainder interest. And the Court of Appeals has said this law applies to every owner. And so it was error for the court below to dismiss the plaintiff's direct claims against 644 BRDY.
Okay, we will take another look. Thank you all very much.
Thank you, Your Honor. It's a privilege to be here.
Have a nice afternoon. The next case for oral argument is BSR Fund versus Jagannath. Not sure I pronounced that right.
Sorry. Good afternoon, Your Honors. May it please the Court. Jonathan Greenbaum for the appellants. The amended complaint and the attachments to the complaint allege significant facts that occurred in New York. The fraud at issue here was carried out in New York and other places as well. But the significant factors took place in New York, namely, the defendant Icon entities, which we allege are alter egos, their CEO, Mr. Jagannath, through his office in New York, who was also the client relation manager to the funds, acted as custodian to the funds at issue here. Not only the custodian, they acted as the liquidity provider. As custodian, they were responsible, in their own words, for safeguarding the client's funds and its client's funds. And they codified that in a letter, a number of letters, when our clients, the plaintiffs in this case, suspected something was amiss with these funds.
Well, yeah, the thing is, I'm not saying nothing happened in New York. I mean, that's not true. But this dispute is primarily amongst your clients who reside in Greece, with defendants who reside all over the world and have offices all over the world, and controlled by some of the Greek defendants. I mean, we're trying, and since the plaintiffs do not reside in New York, then I know they can choose the court here, but we look at it a little bit differently. Certainly the residency is one of the things we consider. I mean, why should we keep this here?
You should keep this here, Your Honor, because I still think there, under the cases, their choice of forum is still entitled to deference. I agree, not as much as if they resided here,
True.
but still entitled to deference. The case should remain here because we assert, and as we allege in the complaint, the significant fraud took place here in New York.
What's the significant?
The significant fraud is, one, the Icon entities, through Mr. Jagannath, were the custodian of the funds. What they did, there's a couple of fraudulent acts they did in New York. That, one, let the fraud be carried out. Two, covered it up. One, as custodian, they were responsible for safeguarding. What we allege in the complaint and what the records show is that during the course of about a year and a half, they transferred out of these funds $56 million. Now, as the custodian, they're responsible for maintaining the client funds. The subscription agreements at issue had lockup periods. They were not supposed to disperse funds during that period. Then, when there was an issue with these funds, they wrote a letter to the auditor of the funds that the funds were safe and secure. And in fact, the funds were never traded. They were just dispersed out. The Icon entities here in New York, through
So
Mr.
they
Jagannath.
wrote a letter to Grant Thornton.
Yes.
Not in the United States.
The letter was written here in the United States.
But it wasn't sent to someone in the United States. It's not Grant Thornton in the U.S., it's Grant Thornton in a foreign country.
That's correct, Your Honor. But the letter was the fraud, which was relied on by Grant Thornton in issuing its opinion that the funds were safe and secure when they weren't. They were not safe and secure. They were demo accounts. They were fake accounts. They were training accounts.
And where are those accounts supposedly maintained?
They were maintained with Icon. And according to Mr. Jagannath, the CEO, he says the Icon books and records were kept at a storage facility, a computer storage facility in Weehawken, New Jersey. Up until when he says he was in charge of the Icon entities, that's in his affidavit attached in the record. He was in charge of Icon until June 2016. The books and records and the client's records, he says, are kept in the storage space in Weehawken, New Jersey. In addition, Icon also owns F-Technics, which created the demo accounts, which was the software platform for the demo accounts. And F-Technics had an agreement with the funds that any disputes regarding that agreement would be litigated here in New York using New York law. So there are significant factors contained in the record and as alleged in the complaint that took place in New York. I will grant the court that there are individuals here that are located in Greece, but there's also significant individuals and fraud that occurred here in New York.
Okay, let's listen to the respondents, and we'll certainly give you a few minutes to respond.
Good afternoon, Your Honors. I'm Edward Floyd from Zeiler Floyd Zadkovich. May it please the court, I'm on for the various Icon entities as well as F-Technics, all of which are defendant respondents. I begin by noting that I am responding now to a number of allegations and assertions that are outside of the record and simply not supported by any of the allegations that are in the first amended complaint. For instance, this assertion that it is a foregone conclusion that the Icon entities stood, any one of them, and that's a separate question to get to there in a moment, but that it would be a foregone conclusion that any one of the Icon entities stood as and had agreed to be the so-called custodian is simply not in the record, is not alleged in the complaint. What is alleged in the first amended complaint is that one Greek told another Greek that a company called Icon would be the custodian. That is not a representation by Icon, and I challenge my adversary to show anything different.
The Icon defendants are located, it seems, all over the world. I mean, I know they apparently have some offices in New York, but also London, Dubai, Hong Kong.
Your Honor, that goes to a very important point there. What the plaintiffs here refer to, and that again is the Greek and the Marshall Islands and the Liberian plaintiffs, what they are referring to as Icon is 6 different companies. The 3 ones that are continuing to be operative right now, as far as I know, or at least at the time of the proceedings below, are Icon Europe. That's an English company. Icon Finance, that's an English company. Icon Atlantic, that is a Bermudian company. Icon Global Holdings Company is a Delaware entity, and all it is a holding company. Icon Global Markets has not been in any form of active business since 2013. That is according to the Yikel Mazzolu Declaration, affirmation, which is in the record. And F-Technics has been an operative company. It is a New York entity, but that is a technology company. It is not an a financial firm. It is a technology business. On top of that, these assertions that a fraud occurred in New York, that is simply not the operative allegation, the fundamental allegation regarding any fraud in this matter. Anything that is alleged to have occurred concerns the misrepresentations that were allegedly made by one Greek or a Cypriot to another Greek in Greece at some unknown time, many, many years ago in Europe.
I just want to ask you
Go ahead.
a question. Your clients did not move to dismiss on forum nonconvenience ground. It was just Mr. Litness's client. So
my clients moved.
Now you're arguing it, but because you wanted it below. But I mean, that was not your position when you moved to dismiss in Supreme Court.
Your Honor, my clients moved on multiple different grounds to dismiss, including for lack of personal jurisdiction. The court is correct that we did not move on forum nonconvenience grounds. However, to that point, number one, 327 of the CPLR, 327A of the CPLR expressly states that the court may dismiss on forum nonconvenience grounds upon the motion of any party, and I'm quoting the any party there. Likewise, that proposition is fully in keeping with the Court of Appeals decision in Mashrep Bank versus Ahmed, in which it was held that there did not need to be in Mashrep Bank, the Court of Appeals did hold that the Court of Appeals, that the court below could properly dismiss as to all parties the entire action, regardless of who had actually made a motion to dismiss on forum nonconvenience grounds. Bottom line here is that the turning point for any forum nonconvenience analysis is whether or not there's a substantial connection to New York, and the court below very fairly and properly found that there is no substantial connection to New York here. Everything is overwhelmingly foreign. This is a dispute between Greeks and other Greeks, along with their overseas offshore entities in the BVI, in Cyprus, in Liberia, and in the Marshall Islands. This billionaire can go fight his fight in his own home country, not here in New York. Thank you.
Judge Pitt, did you have a question? You sure?
I had one question. Is there any potential hardship posed on the other parties?
Your Honor, I would say there's substantial hardship posed on these parties that are not in New York. The English companies are not here. They're in England, as well as in Bermuda. Most importantly is that if the order did not stand, witnesses are located all around the globe. Predominantly, those witnesses are in Cyprus and in Greece. And
Isn't London closer to them, and isn't Greece closer to them? I know there's limitations with respect to Greece that you allege, but isn't London a viable forum?
London could potentially be viable. The defendants, though, the witnesses that would be necessary are not here in the US. They're also, as far as I know, not in London. They are in Greece. But that would be an issue that would seem to be one that the plaintiff could sort through, since the plaintiffs as well, both Mr. Restis and Ms. Resti, are located in Greece themselves. They would not have any inconvenience there.
Oh, okay, thank you. We'll hear from, you represent Litness, right? Defendant Litness? Is that correct?
Sorry, Your Honor?
You represent Litness?
Mr. Latinas, yes.
Yeah, I'm sorry, I pronounced it wrong. I apologize. Okay, you have 3 minutes.
Good afternoon, Your Honors. Patrick Lennon from Lennon, Murphy, and Phillips for Respondent Giannis Latinas. I'm not going to add too much to what my colleagues had to say. The record before the court, I think the thing I would add is that the court's decision below is entitled to deference here. It's an abuse of discretion standard. In this particular instance, the court evaluated all of the evidence, evaluated all of the factors that the Court of Appeals has laid out in Pavalli. The court has had extensive argument by both parties. It assessed all of the factors that the court is supposed to assess in a forum nonconvenience motion and properly concluded that all of the substantial facts that relate to the alleged conspiracy that is claimed in the complaint happened in Europe, either in Greece or in London. The minimal facts that the plaintiff has been able to allege and point to in the United States have to do with peripheral issues. And mainly, the argument is that a letter was drafted by somebody here in the United States, and in fact in New Jersey, that was then taken, and it's alleged by my client, and presented to the plaintiffs as part of this conspiracy. And that is the fraud that they're claiming. That fraud did not happen here in New York. The fact that the letter was drafted here is almost irrelevant. The conspiracy, if you read the complaint as a whole, all points to actions that happened either in Greece or someplace else in Europe. But none of those facts that are alleged in the complaint that relate to the conspiracy and the alleged fraud occurred in New York. And so from the substantial nexus standpoint, which is one of the most critical factors on forum nonconvenience, this case was properly dismissed. And I would only add that in respect of my client, the appellant's own briefs suggest that they actually really don't have an issue with the dismissal as against Mr. Latinas on forum nonconvenience grounds, because they have alleged virtually no facts that connect Mr. Latinas to any of the things that happened allegedly in New York by any of the peripheral players. So from that standpoint, they only really half-heartedly appeal the decision as it relates to Mr. Latinas. But as my colleague had said, under CPLR 327A, the court properly dismissed the entire case because had it not, my client would have potentially been exposed to being dragged back into this case or having efforts made to drag it back into this case on third-party type actions. So the dismissal was proper. Thank you.
Thank you.
Couple of points on rebuttal, Your Honor.
Sure.
With respect to the custodian issue, one just has to review those letters. Mr. Jagannath says, ICON has agreed to controls, has set up controls to maintain and safeguard the funds. They're acknowledging they're the custodians. With respect to ICON entities, now, they didn't raise the forum nonconvenience, and why? Because they filed a very similar case a year before, 2 years before, in this court, in New York Supreme.
And I know that Judge Cohen considered that.
Judge Cohen didn't consider that. And that gets to the Julius Baer case, where this court reversed a finding of forum nonconvenience, where the court did not consider a similar fact. There, it was a motion to compel arbitration. And the court said the judge put too much emphasis, this court said the judge put too much emphasis on alleged fraud taking place overseas and missed that fact that the defendant in that case actually filed a motion to compel arbitration before making the argument. Here, F-Technics and ICON never made the forum nonconvenience argument, and if the court reviews docket number 657-284-2017, the case brought by F-Technics, and you look at the parties in that case, they're the same exact parties. Now, what happened in that case? The only one who was served and answered or filed a motion to dismiss was Litnos. Did he raise forum nonconvenience? No. He removed the case to federal court, Southern District, 18 CV 02210, and filed a motion to dismiss, not on the grounds of forum nonconvenience, but on the grounds that the complaint failed to state a claim under civil RICO. The case ended up being dismissed, not by the court, but voluntarily, because the Second Circuit came out with a RICO decision saying there was no viable cause of action. Now, there's another case with Judge Cohen.
I got to tell you you got to kind of finish up. So
Can I do one more point, Your Honor?
one point, that's
Okay.
it, 30 seconds, that's all you got.
There's another case sitting with Judge Cohen regarding these parties as well. Now, with respect to 327, the court can dismiss in part, and we've argued an alternative ground, that the court could dismiss out Litnos. No one else has raised the issue. Clearly, New York is appropriate for those claims. There are certain claims in this complaint where only ICON and Jagannath are the defendants. Those are appropriate to maintain in this court.
Okay, I know that was argued in the briefs, I saw that. So
Yes.
we will certainly take a look at that again. Thank you.
Thank you, Your Honor.
Thank you all for your time. The next case for argument is Una RT Corp. And Golden Pacific. Okay, counsel, you may begin.
Good afternoon, Your Honors.
Good afternoon.
If it please the court, my name is William Schwartz of Cooley LLP, and I represent the parties who are referred to in the papers as the true respondents. When petitioners brought this proceeding nearly a decade ago, they chose to bring it as an Article 52 turnover claim against my client, who they specified were third-party garnishees. In order to satisfy their judgment against an entity called NYGFI, and it was not brought as a direct action against my clients. Today, faced with precedent of this court and of the Fourth Department that is on point, that they are not entitled to a jury trial on their turnover claim, they attempt to recast the special proceeding into some kind of direct plenary action. In Jonk v. Footlocker, this court, in a panel in which Justice Friedman and Justice Gonzalez sat, held that a person seeking to enforce a judgment against a party other than the judgment debtor is not entitled to a jury trial because that claim is equitable. That is exactly the situation here, the attempt to enforce a judgment against a non-judgment debtor. In making that ruling, the court cited the Fourth Department's decision in Lakeview Advisors, which was directly on point with this case, which held that a judgment debtor who brings a turnover claim under Article 52 against a third party is not entitled to a jury trial. And both those decisions are supported by reasoned analysis by Professor Siegel.
Counsel, don't the petitioners have a legal claim here?
Your Honor, I'm unable to hear you.
I'm sorry. Don't the petitioners have a legal claim here?
To the extent they have a legal claim, Your Honor, they are deeply buried.
Counsel, wouldn't money damages make them whole?
Excuse me?
Wouldn't money damages make them whole?
It must be my hearing.
Can't hear me?
No, you have to talk loud. He can't hear you.
Okay. I'm saying, wouldn't money damages make the petitioners whole here?
No, there is no claim here for money damages. There's a claim for turnover of assets to either a trustee or a sheriff. The lower court just completely misconstrued this claim.
But there's a judgment in question, and if the money was paid, they would be made whole, right?
No, they have asked that assets be turned over to a sheriff or to a trustee, and that those assets could then be monetized and turned over to them, but that's not money damages. The fact that an asset has money value does not turn it into money damages. Indeed, in the Lakeview case, the asset that they sought from the third party was cash, and the Fourth Department held that that was a turnover. Since it wasn't being paid directly by the judgment debtor, it's a turnover proceeding in equitable nature.
Don't they also seek a judgment against the Chews and the banks in the amount of the judgment that they had previously obtained?
They are saying that they obtained the money from the debtor in a way that gives...
And besides wanting a turnover, they just simply want a money judgment too, don't they? If they don't get a turnover, they want a money judgment.
They don't plead a direct claim against the Chews, Your Honor. They plead a claim. They say that there was a fraudulent conveyance that deprived the judgment debtor of what was its. They're not saying that
do they seek a judgment against the Chews and the banks in the amount of that underlying judgment?
They have a judgment.
Right.
They had a judgment against the Chews.
They have a judgment, and do they in this proceeding seek a judgment against the Chews and the banks in the amount of the judgment?
They seek a turnover, Your Honor. They have the amount of the judgment against the Chews was already paid. They had a federal judgment against the Chews. The Chews satisfied that judgment. By the way, the Chews had a federal judgment against them, which has not been satisfied. This case was not a direct case against the Chews. It is a turnover action against them.
Okay, we'll hear from the other parties, and you'll have a few minutes to respond. Thank you very much. Counsel.
Good afternoon, Your Honors. My name is Jacqueline Chung. I am an attorney at White & Case, and I represent Agricultural Bank of China, and China Construction Bank. Now, counsel for the two appellants has already laid out the legal framework that applies here. This is an Article 52 proceeding. That is what is stated at the beginning of the petition. This action is brought seeking relief under CPLR 5225 and 5227. It's seeking claims for turnover against parties who are not the judgment debtor here. In addition to the Jockey case that counsel mentioned, and the Lakeview case that case references, there's also the Adelaide Products case that was decided by the First Department in 2007, in which Justice Friedman was also on the panel. This was a case that was seeking to enforce a judgment against a non-judgment debtor entity who owed a debt to the judgment debtor. And in that case also, the court said that inasmuch as this is an equitable proceeding, the right to a jury trial has been properly denied. And that is exactly the situation that we are in here, and any attempts to recast this action as a declaratory judgment action simply don't apply here. And to answer this court's question, this is not a case in which, based on the petition, petitioners could be satisfied simply by a money judgment. First and foremost, this is a turnover proceeding, and it's inherently equitable in nature. But also with respect to the banks, it's not just settlement payments that petitioners are seeking. They're also seeking the turnover of current and future profits and revenues associated with 8 different construction projects in China for which the judgment debtor, NYGFI, only owns a percentage of these interests. For that reason, petitioner is asking for an accounting, which is an equitable form of equitable relief, in order to ascertain what it is exactly that NYGFI would even be entitled to. In addition to that, the petitioner has asked for a receivership under Article 52. And these are all aspects of the relief being sought that show that it's not purely monetary damages that are being sought here. There's equitable relief, and the law is clear that when you have these kinds of relief, the right to a jury trial is precluded. Now, as counsel mentioned, petitioner made a choice at the beginning of these proceedings. He did not bring a plenary action. In fact, a plenary action was brought before this turnover proceeding, and it was voluntarily dismissed. Now that we're in the context of Article 52, there is no prejudice because the petitioner has made the decision to bring this kind of proceeding. The only another point that I wanted to make, Your Honors, is that in the papers, petitioners suggest that this court is bound by a prior decision at the motion to dismiss stage, where the court held that for purposes of the separate entity rule, the banks were not garnishees of their customer accounts. Now, petitioner cites this decision to say that, well, this is a situation when the banks are not garnishees, as this court has already found. But that's not the case. That case dealt solely with the issue of whether the separate entity rule would preclude a turnover proceeding here. And the court did not say that the banks are not garnishees, period. It just said for purposes of the separate entity rule, the banks should not be considered garnishees of their customer accounts. So the court is not bound by that decision. Finally, Your Honors, I would just say that there's clearly equitable relief that's being sought here. This is not a declaratory judgment action, as petitioners note, as petitioners try to recast in their papers. To the extent that there's any request for some kind of declaratory relief, that is ancillary to the turnover proceeding, which is the primary proceeding here. If nothing else, Your Honors, I will just address any further points on rebuttal.
I think we got your point, so thank you very much.
Thank you.
Good afternoon. May it please the court. I'm Henry Sauerborn on behalf of the respondents. Justice Love correctly denied the appellant's motion to strike the respondent's jury demand. He recognized that although the respondents sought declaratory relief, they can obtain full and complete relief through a money judgment and therefore they're entitled to a jury
Did
trial.
you ask for a money judgment?
Absolutely, they did. And if you look at page 33 of the record in the wherefore clause under item number 2, it says that they wanted to, the wording doesn't work exactly, but it says they're seeking a granting of judgment against the appellants in the amount of the respondent's judgment. That's what this.
In the amount of,
I think it's around the amount of the appellant's judgment at the time, whatever that was. So, and, you know, the rule under CPLR 4101 is not a bright line test, I would submit. There are actually, that there's any reference to equitable relief that settles it once and for all. There's certainly much more nuanced than that. There are many decisions from this court which say, what I believe you were saying is, in essence, you have to look at the thrust of the action, at the essence of the.
What about the cases that Mr. Schwartz pointed out to us in the Fourth Department and another one from the court here, which seemed to pretty much go the other way? How do you decide those cases?
I think that's difficult because it's clearly not a clear action. I think you have to look, again, what you have to do is you have to look at the essence of the action. And
Well, I
there are
mean,
cases like Strockman.
a declaratory judgment action, I always thought was kind of an equitable remedy, but that's pretty much what it is. Now, I guess in the alternative, you're asked, if you can't get a turnover, you want a money judgment, but isn't that overwhelmingly equitable as opposed to overwhelmingly legal?
Well, I think cases like Strackman versus the Palestinian Authority say that you can have that kind of claim, but you're still entitled to a jury trial. Again, you have to look at what the essence of the action is, and here it's in essence for a money judgment. And that's what they're seeking. I guess I would analogize it to paraphrase the late Justice Stuart Potter. It's you know when you see it. And it's the respondent's position that this claim, when you look at its essence, they're really seeking money from these tortfeasors. They stripped this company of the judgment debtor of assets. They took money and property and so forth, and they're just basically, we need a judgment against them to be able to collect on that. And that's in essence what they're seeking. Unless the panel had more questions for me, I'll rest on the rest of the arguments in our briefs.
Okay, thank you very much.
I would request that the panel take a close look at the petition itself in this case. It is about garnishees and about having assets that they claim belong to the judgment debtor turned over. That is the whole gravamen of this case, that there may be an ancillary claim for damages, which it's not clear to me what the claim is based on, doesn't turn this away from being an equitable proceeding.
what your colleague says is that there was a request for a money judgment.
And the cases say you don't look at the addaminum clause to determine the nature of the case. What you have to do is read the petition. And what the petition is about calls us third-party garnishees who are holding the assets of a judgment debtor. That's the case that Your Honor, with all due respect, in a panel that you sat on, said that that's a case that sounds in equity. It's a case that derives from an equitable action, as Professor Siegel describes, which is called a creditor's bill of equity. They don't owe the money directly to him. There's no claim like that. They want the judgment satisfied. It's not a judgment against my client. My client satisfied its judgment. So we're now talking about satisfying the judgment of someone else. And they say we have assets of that someone else, and we have to turn them over. That's the nature of this case. It is a classic turnover proceeding, a case where you sue someone to turn over assets to satisfy your judgment against someone else. And even if there is a claim against us for money damages, it is combined in this case with that action, with that claim, and therefore it's a mixed claim of equity and law, and it's not entitled to be tried by a jury. It has to be tried by the court. That's the long-standing rule in this state. When a plaintiff brings a case that mixes equity and law, he's stuck with equity unless the defendant asks for the legal parts of the case to be tried by a jury.
Okay, thank you very much. Counsel, you have 2 minutes also, if you have anything to add. Oops.
Your Honor, Your Honors, I would just note, as counsel mentioned, this is a turnover proceeding. The banks here are not judgment debtors. There's been no action brought against them. This is purely an Article 52 proceeding in which the petition states no fewer than 4 times that the non-debtor respondents are garnishees under CPL or Article 52. So any attempt to recast this as some kind of action against the banks at this stage seeking a money judgment is simply incorrect. You need to go back to the petition to see the specific relief that is being sought here, and the very first words of the petition is, "This is a turnover special proceeding." That's precisely the relief that is being sought here. And any attempt now to take away certain forms of equitable relief that were requested in the petition should not be considered. The only other thing I wanted to add is that this whole idea of looking at the essence of the action, you can do that up to a certain point. First of all, you have a turnover proceeding, and the law requires that in these actions, if you're seeking relief against a party other than the judgment debtor, you have an equitable proceeding for which a jury trial is not permitted. This idea of looking at the essence of the action like you would for perhaps a declaratory judgment action, as is suggested in the Struckman case that petitioner cites, is only relevant to declaratory judgment actions where there's potentially ambiguity as to whether or not historically the underlying action would be considered equitable or legal. There's no wiggle room in these kinds of turnover proceedings where you're seeking relief against a non-judgment debtor party. That's all I have, Your Honors. Thank you.
Okay, thank you very much. The next case for argument is Newmark Partners.
Good afternoon, Your Honors. Theodore Boutros from Gibson, Dunn & Crutcher. May it please the Court, I represent the brokers Terrence Hunt, Christopher Cowan, and Shane Osment. We respectfully request that the Court vacate the preliminary injunction in this case. The Newmark did not meet the exacting standards that apply here and must be met by clear and convincing evidence. It's a drastic remedy.
But I mean, the thing is, in this scenario, these are, I would think, somewhat sophisticated brokers. I mean, they've been working in the brokerage field for some while. They were all part of another company. When they came, when their company was bought by Newmark, they got a certain amount of, they entered into contracts. And they got a lot of money, it seemed like to me, and they entered into these contracts which had these non-competes in them, which is not unusual in this area at all. They knew they had these non-competes, and yet they all left with perhaps a bunch of other people, at least that's the allegation. They encouraged other people to leave Newmark, and they went to a major competitor. I think this is out in Colorado, right? How could they not anticipate that, they did really anticipate that they would be subject to these non-compete clauses, which are permitted once they went and left and advertised and everything like that. And even the agreements with the new company, CBRE, seem to say that we'll give you certain other things, we'll put you in a different division, we'll try to help you out while the non-compete exists. So I don't know, it's kind of tough to overcome when those are what non-competes are. I've seen them, loads of them, and so have you.
First, Your Honor, it's really important to note that the purchase agreement that Newmark entered into back when this happened, these brokers, they weren't the owners of the company. They each had a 1% interest.
Right.
They didn't know that there was a non-compete, and the record reflects this, that bound them in the purchase agreement. It's buried in 150 pages. They weren't negotiating that agreement. They had service agreements that did have a non-compete that would ended at 5 years. So this provision is draconian. Nobody else has these sorts of provisions in purchase agreements. And our point, Your Honor, is that by the time they left 7 years later, Newmark had recouped all the goodwill from the purchase many millions of times over.
Well, that's what you say, but I mean, that's not what they say.
That's correct, Your Honor. And this is a preliminary injunction. All we're asking for is to let us try this on the merits. We will show that on the merits. They did not show any irreparable harm. We're talking about equity here. They can get money damages if they're correct.
Well, how do you feel? Because they're saying this could injure their name, their reputation as Newmark, and how do you don't get that back? That's hard to get money down.
Well, there's just no evidence there. It was extremely conclusory. In the speculative, they mentioned 2 clients that complained back when the brokers left. They were complaining about how Newmark treated these brokers and didn't let them transition and were binding them forever. They acted in bad faith when they negotiated. The record is filled with this. And we just want a chance to litigate this on the merits. It's having gross irreparable harm effects on my clients.
Supreme Court cut the period of time that you could have been subjected under the agreement in half. Because since they left in less than 7 years, that original purchase agreement would have permitted a non-compete for 2 years.
No, Your Honor, the original service agreement ended when their employment was over. So under the service agreement, their employment agreement, which really is what should be
But if they left in less than 7 years, then there was a non-compete for 2 years, wasn't
That was in the purchase.
That was in the purchase agreement. And it's
For
really
the purchase agreement, they received around $140,000 each, right?
They did, and they made tens of millions of dollars for Newmark, way more than the total purchase price. So our point is that this provision no longer serves any legitimate purpose. It's a naked restriction on competition, and there's almost no injunction that's more severe than this kind, where you're restraining personal service. This is destroying, it's an unrebutted testimony.
But these were intelligent people who basically sold. They had to sign the purchase agreement and they had to sign the service agreement because they were 1% interest holders, and therefore, when there was a purchase by Newmark of, what is it, ARC? They were sellers.
They were, Your Honor.
They knew what they were negotiating, did they not?
They did not have any negotiating power over that purchase agreement.
But did they have the ability to read the agreement?
They did. They were provided with the agreement. They were told they needed to sign it, or they would be done and they wouldn't be coming over. And this is the point. There was maybe a legitimate purpose in that agreement, in the non-compete, early on. If they had left a day one or in a year, they stayed for 7 years. The cases we cite, the Reed Miller lumber case, Mill lumber case, the Copeland case from Colorado, go right to this point. At some point, it becomes unreasonable to shackle, to imprison them. And I know my time's up. I just want to make one point before I sit down.
Shackle them outside of Colorado, right?
That's where they're licensed. That's where they make their livelihood. They have been sidelined. Their careers have been completely disrupted. They can get damages.
Can't they, they were in what they said the multifamily partners.
Yes.
I guess that means apartment houses.
Right.
Can't they do something else? I mean, there's other kinds of, can't they sell houses for 6 more months? Or
Not in Colorado. They can't engage in
houses in
any
Colorado.
brokerage activities in Colorado. This is egregious. It's putting them away. And this is the point I want to make. Here, if we win at trial and we put on all our evidence and show there was fraud, they were lulled into this, Mr. McCabe from Newmark told them they could leave in 5 years. And if we win at trial in a year, this will be a lost year. We can't get it back. And that's the kind of injunction that New York...
I understand. And Judge Ostrager did hear this very quickly and made these decisions very quickly. And based on what I saw he said on the record, he hoped that you guys were going to work this out, which I would have also if I was in his position. Let me hear from the respondent.
Thank you, Your Honor.
And then you have 2 minutes to respond.
So, counsel, your adversary...
Wait, let him just introduce himself
I'm sorry.
before you ask him.
Good afternoon, Your Honors. David Paul on behalf of the respondent, Newmark Partners.
So, counsel, your adversary says that His clients are being held hostage. They're being imprisoned for a year. What do you have to say for
That's absolutely not supported by the record, Your Honor. As Justice Kapnick pointed out, this was a raid by the former owners of the business that they sold to Newmark, and then they sold it a second time to Newmark's #1 competitor, CBRE. And when they signed contracts with CBRE, they obtained insurance for themselves. Their contracts stipulate—
Who obtained? The individuals?
The defendants did. They have guaranteed contracts that provided them upfront bonuses of more than $7 million, upfront cash payments of more than $1.3 million, and a guarantee—
But don't they have to produce results in order to keep that?
Correct, but any time that they serve for an injunction will not be counted against their term of their contract for them to earn the production. That's in the terms that they negotiated with CBRE, so that they will not be impacted by any injunctive relief that is awarded.
Are you suggesting that they negotiated the terms with CBRE with the knowledge that for a year they might be stuck with this non-compete?
They negotiated it with the knowledge— the record shows that they negotiated it with the knowledge that they may be facing a 2-year injunction under the contract, because they left, as the panel has pointed out, before the 7-year duration after the sale. Where this is the purchase agreement. There's some comments about whether there was a services agreement and a purchase agreement. This is a commercial transaction. The contract with the non-compete, as Justice Kapnick pointed out, is a common provision in sales of business, where you have senior, sophisticated management and executives that stay with the business and then have some period of time after they leave where they cannot compete, in order to ensure that the buyer obtains the benefit of the bargain.
But then, just because I ask questions doesn't mean, that's where I am. I'm trying to ask both of you questions to sort of get to the bottom of this. But isn't 7 years a pretty long time? And then they leave right before the end of the 7 years, and it's still 2 more years that they got to do something. It's a long time, no?
Well,
it's as your adversary said, didn't Newmark reap the benefit of all their contacts by the almost 7 years?
Well, the question at this point is whether the trial court abused his discretion in finding that the contract is reasonable and enforceable under Delaware law. And to your point on duration, the trial court did not abuse his discretion. The contract provides that if the defendants were to leave within the 7-year period after selling the business to Newmark, then they would have a 2-year non-compete obligation. The purchase agreement states that it was a material term designed to induce the purchase of the business. Then the contract says that if the defendants leave the business anytime after 7 years, there's a step down, a 1-year reduction, 50% reduction in the duration of the non-compete.
And Judge Ostrager also limited the geographical
He did.
scope.
He took the scope as national because their business is national in scope, and
just
he
limited
blue-penciled it in their favor. He also blue-penciled the duration in their favor. So the agreement is enforceable as written, but then the fact that Justice Ostrager blue-penciled both the scope in terms of geography and also the temporal scope in their favor underscores that he exercised his discretion soundly and that there is no abuse of discretion in this case. On the balance of the equities piece and this parade of horribles that we're hearing about, the defendants' lives are in jeopardy and they have no ability to earn income, I turn you back to the record and the details of their contract that they have with CBRE. They have a job waiting for them. They have upfront money to pay for that, for their livelihood and a go-forward contract. And they also have brought over the entire team. The record shows that this business was gutted completely. The entire business was taken. We have a gaping hole in Newmark's West Coast
You mean like that was a
presence.
division? Is that what you're saying?
Correct. They took everyone. They took all the clients, all the goodwill, all the reputation, all the other employees that the defendants and Newmark hired together over the years as they built this business. They took everyone. And they did it in a way that it inflicted the maximum amount of punishment to Newmark. They gave us no notice, and instead of sitting out and non-competing for 2 years, they sat out for 1 day while they transitioned between Newmark and then CBRE, and they hit it with a media blitz that maximized the impact. That's why irreparable harm was evident, and that's why the trial court did not abuse its discretion. This court should please affirm the decision below. Thank you.
Thank you.
Your Honors, that just is a fictional accounting of the record. There was no raid. They didn't take the entire division. At least two brokers stayed at Newmark, and one of the executives took over.
How many left?
5 plus these 3, and this is important,
No,
Your Honor.
more than the majority, yes?
More than the majority, but now 5 of those brokers and one of the operational people are right now at Newmark. So how can they say that it's irreparable harm requiring that these 3 professionals, and they're the victims here. They were treated terribly by Newmark. Newmark used this provision to bludgeon them to try to keep them another 10 years. This court should not countenance that kind of inequitable behavior. They can get damages if they could prove any of what they said. It's rhetoric. It conflicts with the record. My clients testified, and it was unrebutted, that sitting out for months in this industry could destroy your career. I believe my career in multifamily would be over. I don't see how I could rebuild my book of business. This is a relationship business. Clients don't wait for you. If you're out a year, it'll take you another 1.5 or 2 years to do a deal. This court shouldn't be part of that. It's inequitable. It's unfair. Those are misstatements of the record. And they can get damages. They're a big company. This is just a minuscule effect on them. And so I would ask the court to reverse, vacate the injunction, and then in 6 months to a year, we'll have a trial on the merits.
Okay, thank you both
Thank you.
very much. Appreciate your time. And last, People versus Schiraldi. Good afternoon.
Good afternoon, and thank you so much for your patience. We hold the unique distinction of being the last case called on an extremely long calendar, according to your
Hope you
court
found it
officers.
interesting. Okay.
But I represent Angel Maldonado. He's the petitioner in this matter. And it's our position that the court committed abuse. The court abused its discretion by remanding the defendant for reasons that were insufficient in law. It was interesting that I included this Port Arreo case in our reply brief. And I included it because I think it illustrates how we've missed the mark here. Bail is not supposed to be set to punish a defendant. It's supposed to be set to secure his presence in court. And I was...
Well, I read what we could hear read, and it seemed that the judge was really concerned at the surety hearing. Is that what?
Yes.
At Judge Statner.
Passenger, yes.
Was concerned there about the fact that there were transcripts of calls from Rikers Island that were presented to him, which indicated that the defendant himself was going to be paying back his friends or the suretors, whoever they were, for those bonds, so that they wouldn't really be out their money, that it would just be on him. And he was, it appears that he was concerned that indicated that there was no guarantee that they would come back to court. Now, maybe he should have been more explicit, or do you think that was not something he should have considered, or do you think he did not consider enough of the points that the statute says, or what are you really focusing on that you think he did wrong at that hearing?
Well, Your Honor, even if the defendant's a flight risk, he's entitled to bail. Honestly, I think that the defendant, Mr. Maldonado, didn't think he was doing anything wrong.
Counsel, there are certain circumstances, even under bail reform, where if it's a qualifying offense, that remand is an option. So that's not necessarily a genuine statement that he's entitled to bail. For certain qualifying offenses, remand might be appropriate as long as the judge can make the record to justify that.
Your Honor, I correct myself. He's bailable. I didn't mean that. What I meant to say is that remand is not mandatory, that he can get bail even if he's a flight risk. But, Your Honor, I don't.
But as I read the people's brief, and as I read the explanation given by Judge Statzinger, it seems like he came to view what the petitioner was saying in those recorded conversations was, don't worry, Schroeder Peralta, about putting up the money and losing it, because even though I may flee, I'm going to pay you back. So the tenor of it seemed to be, at least that's the way Judge Statzinger saw it, is that the petitioner was already planning his flight, and that's the way the judge understood that conversation. And that being the case, didn't that provide a basis for Judge Statzinger to say, well, the petition is going to be remanded?
Well, Your Honor, he didn't say that. The petitioner didn't have that conversation with Peralta. He had it with a third party. So this wasn't like him saying to Peralta, don't worry about whatever money you put up.
I stand corrected. He had it with a third party as to what to tell Peralta.
Well, we don't know if he was going to tell Peralta. I don't know, what.
But that's not the point. It's that this is what the petitioner is saying to someone, and he's caught on tape, and that's the way Judge Statzinger understands it. And if that's a reasonable way to look at it, doesn't it follow that Judge Statzinger did not abuse his discretion in changing petitioner's status to remand?
Your Honor, I think that it's not something that was borne out by it. While it is an alternate interpretation, it's not supported by certain facts.
I mean, why else? Well, I understand, any conversation can be interpreted in different ways. I mean, why else does the petitioner tell someone, the person shouldn't worry about losing their money because I'm going to pay them back? If you're not fleeing, of course the person's not losing their money.
Your Honor, I think Mr. Maldonado didn't even realize what he was saying was incorrect. And I say that because if you look at the hearing on page 60, even his counsel said, well, it's okay for him to pay him back as long as the money is not from a criminal source. So I think Peralta just wanted to say, look, I think that the defendant was just trying to say, I don't want you to get hurt here. You're not going to get hurt. Meaning, talking about just the premium on the bond, and that's all that the conversation was about. The other portion of our brief was about due process. The counsel was there with the 5 people that were the suretors, and 3 of them were people who were on the phone. They could have, and the defendant was not allowed the opportunity to have them come up and speak and present and question them.
Does his counsel say to the court, Judge, I want to call these people as witnesses? Did he ever do that?
He did not, Judge, but he was not given the opportunity. The court said, I've heard enough, and he ended the hearing. There was no.
He said he's heard enough. He said, well, Judge, I have something else I want to say. I mean, I have these people here. They're here in the courtroom. I want to call them as witnesses.
Your Honor, I can't disagree with you. Hindsight is 20/20, but I think that maybe counsel was caught on the back foot a little bit. Maybe he wasn't prepared. There seems to be no tactical reason for him and no for him not to offer to.
Well, I mean, I would say in defense of counsel doing that is because he recognized that Judge Statzinger had come to the conclusion that, rightly or wrongly, I'm not saying anything about that, but that Judge Statzinger had come to the conclusion that the petitioner is planning to flee and he's not going to let him out, and that he had a basis for that conclusion.
Your Honor, also another conversation that the defendant had in jail was telling another person, I want to fight my case on the outside. I can't fight it on the inside because because of all the lockdown restrictions, and it was part of our original application to the habeas court. So that's out there too. And that's an indication that he's not going to flee.
Okay, I appreciate your answering all the questions that we had, and we'll give you 2 minutes, or we've given you 2 minutes for rebuttal, okay?
Thank you, Judge.
Thank you very much. Let's hear from the respondent.
Good evening. May it please the court. My name is David Torreblanca, and I am here on behalf of respondent.
Counsel, I just want to ask, why wouldn't the appropriate decision by the judge have been to just deny the surety and have the defendant produce other sources other than these ones? Why go straight to remand? Why was that appropriate?
Well, the bail court did not abuse its discretion in finding that remand was the least restrictive means of ensuring.
Well, counsel, before you get there, was this a bail application? This was a surety hearing.
This was a surety hearing, right, but the evidence at the surety hearing showed that petitioner attempted to corrupt the bond process, including by covertly funding his own bond that was purportedly funded by indemnitors. He tried to funnel his money to indemnitors so he could shelter the true bond proceeds from court scrutiny. He can't unring that bell. So any bail package in the future, so say Justice Statzinger increased bail, any bail package in the future would have suffered from that same fatal flaw.
Well, if a person who's come into the surety hearing can produce documentation as to where they in fact have the money, they have a job, a bank account, a house, whatever the case may be, isn't that all that's required?
But nothing is to stop petitioner from funding that bond again. So regardless of whether that indemnitor had money in his bank account, for instance, petitioner has already shown his willingness to flee by, one, securing his release by illegitimate means, and then two, by funding his own bond secretly. So regardless of whether an indemnitor actually had money in a bank account, it doesn't change petitioner's flight risk.
What about counsel's argument that there were 5 witnesses waiting to testify?
Right, Your Honor. So the record speaks for itself. Defense counsel never tried to call those witnesses at the hearing. The bail court never denied a request to hear from witnesses at the hearing. In his ruling, Justice Statzinger said he didn't need to hear from witnesses. That was an ideal opportunity for petitioner to stand up and explain why the court did need to hear from witnesses. At the very least, defense counsel could have lodged an objection. Defense counsel was silent. If defense counsel wanted to call witnesses at the hearing, the time was then. He should have stood up and said so at the bail source hearing. So to the corrupting the bond process, which is really the crux of Judge Statzinger's decision here. Considering the calls and the parties' arguments, Justice Statzinger reasonably found the petitioner, one, as we've talked about, tried to hide that he was true source of the bail funds. Two, he encouraged an indemnitor to lie on his behalf to, again, illegitimately secure his release from prison. And three, he planned to bail out his co-defendant because he feared that co-defendant might cooperate against him. So the bail court concluded no amount of bail or other condition would reasonably assure petitioner's return to court.
Counsel, where do you get that interpretation that he wanted to bail out the co-defendant because he feared that he was going to cooperate against them?
Right, so I believe the call was 129, which I discussed in my brief, and it's less than direct, but again, all of these calls.
All he says there is that the co-defendant's getting, I think the word is antsy.
That was the people in the record speaking, but the underlying call itself, which was discussed at the bail source hearing, has more flesh to those bones. And it's very clear that petitioner is desperate to get his co-defendant out of jail. I think to conclude the call, he says 4 or 5 times, we have to get him out, we have to get him out, we have to get him out. And the reason for that, I think, is clear. He knows the call is recorded, and he can't be explicit to say, hey, we have to get this guy out so he doesn't cooperate against me. I think he's obliquely saying, and I submit that he's obliquely saying that we have to get him out to keep him from doing any damage to my case. So petitioner's reply brief, beginning on page 8, I think really highlights the bail court's reasoning here. Petitioner points out that Justice Peck and Justice Statzinger initially found that bail was appropriate. So what changed? At the bail source hearing, Justice Statzinger learned that petitioner was attempting to secretly fund his own bond. He learned an indemnitor had thousands of petitioner's own dollars ready to be used towards the bond, but that petitioner didn't want that said on a recorded phone call. He learned that none of petitioners' loved ones, friends, family, the indemnitors on the bond, would ultimately have been liable for the money on the bond. And remand was appropriate because any future bail package, as we've discussed, would fail for that same reason. I'll also point out the fact that he tried to trick the court into accepting a fraudulent bond speaks volumes about the amount of respect or lack thereof that he has for both the court and the court's orders. He has shown that he would be simply disregard any order to return to the court.
Thank you very much, counsel. You'll have 2 minutes to respond, or you do have 2 minutes.
I just want to,
Counsel, just if the interpretation is correct, that the defendant was trying to subvert the surety system, right, by funding his own, either the premium or any loss that results of him not, that would result from him not returning on the bond. Do you agree that that's against public policy?
Your Honor, I have difficulty answering that question because I don't think that's what he was trying to do.
Well, let's assume that that's what it was. Is that against public policy?
If he was trying to subvert the bond process. Your Honor, I think it's a difficult question to answer, and I'm trying to be as intellectually honest with you because I believe the bail statute allows a person to put up their own home as on a bond. I think that's permissible. But what I believe is the issue here is the surety signing something saying I'm on the hook for this and knowing that they aren't really the person who's on the hook for it. That's what I believe is the real harm here. And I don't think anyone ever asked Adolfo Peralta if he was being funded. I don't think that Adolfo Peralta had the chance to say, I don't care what this guy says, I'm gonna do the right thing for him. I think that this is what could be this is what would have probably happened in this situation. I think we're in a dangerous position when we let the argument of the district attorney substitute for evidence. And I mean, he said a lot of things that just aren't born. He didn't funnel any money to anyone. There's no funneling of any money. He didn't try there's a lot of things that he said that just are simply mischaracterizations, and they're really unfair characterizations, because the district attorney's office, you know, they're the ones who have the phone calls. They're the ones who get to pick and choose which phone calls to turn over, and they're the ones, and the defendants just don't have that opportunity. Anyway, Your Honor, I appreciate your time and your attention, and I know we're all tired. And thank you so much for your attention at this time.
Thank you. Thank you both very much.
Be advised. Court is over. We got 3 coming out. Will do. Thank you. I'll grab it.
I remember that one. That one took about
Thanks so much.